Yes,
I will mention item number 35, my lord.
35. Yes.
The counsel of the petitioner is not present today, my lord.
Huh?
He is absent from the court today
Who?
for his personal difficulties, my lord.
Who?
Counsel for the petitioner, my lord.
Who you are? You are for?
I am on behalf of the SB Chaudhary.
Yeah. Mr. So-and-so learned counsel
Better maybe password for the day.
appearing on behalf of MS SB Chaudhary, learned counsel for petitioner. Press for adjournment of the matter on the ground of MS Chaudhary having some personal difficulties. Prayer is allowed. Adjournment prayer is allowed. List after 4 weeks.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention, lordship, item 21 and 22. Lordship, here in this matter, Mr. K. Gogoi appears, lordship, for the higher education department. Lordship, I am seeking for some accommodation for a week.
On the prayer of Mr.
The Upamanya.
The Upamanya Standing on Higher Education
Yes, lordship.
Department. List this matter after 3 weeks.
My lord, if I may, my lord.
2 weeks.
I'm for the petitioner.
So as to enable him to file.
No, lordship, not to file, lordship. Mr. K. Gogoi is appearing in this matter, lordship.
He has some difficulty.
He has some difficulty.
My lord, there is some urgency. If your lordship just have a look, it is by order. That
3
is why.
2 weeks, 2 weeks, 2 weeks.
Can it be on Tuesday, my lord, next week?
2 weeks after that, after 2 weeks.
Highly obliged.
May I please?
Yes.
I beg to mention item number 34 from the daily list, lordship. With due consent of the other side, lordship.
You are for?
I am for the petitioner, lordship.
On the prayer of Mr.
Only password for the day. The Google.
I'm paying for all the respondents, lordship.
Appearing on behalf of. Huh?
Petitioner. I am for the petitioner.
Your name is not there.
Yes, lordship. On behalf of Mr. Ayat
No, it's not there for list this matter after 4 weeks.
I'm paying for all the respondents,
2
lordship.
weeks.
2
2 weeks.
Hello,
May I please, lordship? Lordship, my senior Mr. Arsasek is not well today. The matter may be adjourned for today.
Item
Item 14, lordship.
14.
1/4.
Yes. On the prayer MS. Yes, kya?
R.
Huh?
Bharali.
R. Bhuya. Then.
R. Bharali.
Huh?
R. Bharali.
R. Borari. Then counsel appearing on behalf of Mr. S. RC Saikya. Then counsel. Senior counsel. List this matter after 2 weeks.
Highly obliged.
May I please your lordship? Lordship, in item number 44, an affidavit in opposition has been filed, lordship, by respondent number 3. That may be called for, lordship.
44.
44.
Yes. 44 is for
Orders, lordship.
orders.
Yes, lordship. An affidavit has been filed on 29/5, lordship. That may be called for, lordship.
Who has filed?
Respondent number 3. Respondent number 3.
You are for respondent number
Yes,
3.
lordship.
Okay. Call for it.
Obliged, lordship.
May I please, your lordship? I beg to mention item number 7 of the list.
7.
Yes, your lordship. We'll have to file an affidavit.
What this? What affidavit?
Affidavit in reply in lordship. In regard the affidavit filed by the opposite party.
You are
dated
for
petitioner, your lordship.
petition. On the prayer is of Mr.
A. Hussain, your lordship.
A. Hussain, then counsel for the petition. List this matter after 4 weeks. So as to enable him to file affidavit in court.
Obliged.
I beg to mention item 10.
10.
Yes, I'm for the petitioner, my lord. 1 week time may be granted because I have to some.
Hari, what is this matter?
My lord, this is my lord, the regularization matter, my lord. Regularization, my lord. They are working for 30 years. So they are regularized, again deregularized, my lord. So this is the problem, my lord. There is in some interview and accordingly, my lord, they are regularized, my lord. That instruction I have with me, my lord. Otherwise,
there is no case.
my lord.
Otherwise, there is no case.
Yes, they are regularized by government. They said the government has not regularized. By government letters, I have had RTI. And RTI, I have placed, my lord. Government take a decision.
Thereafter, what had happened?
Then they reverted back from the board and they says, you are in workshops now.
Yes.
Doctors. So that is our case. But when there is in board, My
what
lord,
do you want to obtain? What sort of instruction you want to obtain?
my lord, they are sent deputation on deputation, and during deputation, government has itself, my lord, regularized them. But only problem is that the urban
On
development.
the prayer of Mr. M.J. Baru, Land Council for the Petitioners, list this matter after 4 weeks.
My lord, one thing is that
Thank you.
urban
Next.
development department
Next.
has not made parties. Can I make a prayer for that? So give
You file
otherwise,
an appropriate application, sir.
my lord, yes, that is why. Otherwise, it's
Lordship, I may be allowed, I will take step during the course of the day. Upon record number 4 and 5.
Hmm?
3 and 4, yeah.
Is there any interim order?
No, yeah.
Okay. Mr. So and so. No, Mr.
K Mira,
K.
Mira, yellow.
Mira, Land Council for the Petitioner. Press for and is granted a week's time to take fresh steps for service upon respondent number 3 and 4. This after 4 weeks.
May I please?
Yes.
This matter, Lordship, pertains for, initially it was for pensionary benefit to the petitioner. Subsequently, the petitioner died and his wife has been.
You have not completed 20 years.
Lordship.
Your husband did not complete 20 years. Is not it?
Completed, Your Lordship. There,
Affidavit is there.
yes, affidavit is also
Who
there.
is for the
Lordship, pleadings are complete. Can this matter be fixed on a hearing day?
why?
Mr. K would be appearing in this matter as a senior standing counsel, but
Call him, we'll decide today.
no, for some personal difficulties, he is not available today.
Why?
For some personal difficulties, I'm not privy to that.
He's not in the,
No,
he has not come to the court.
no, Lordship.
What do you say?
Now,
As per the rules, you have to complete 20 years.
yes, Lordship.
And then
As per their affidavit, Your Lordship,
you are just 17 years, 9 months, 30 days.
yeah, for regular. And for temporary employee, I was working for 13 years, 10 months and 20.
So you want that it should be calculated. Where is the law? Where is the law?
Since total Lordship, 31 years, I am.
See, the regular, the period of your regular service is 70 years, 9 months, 30 days,
Lordship,
right?
Lordship.
Therefore, you are not eligible for pension, right?
Lordship. Now, Lordship,
Because you have not completed the required qualifying years of 20 years.
Lordship. Since Sanjita Roy's case, Your Lordship, 10 years is regular service,
Huh?
may be counted for regularization. Sanjita Roy's case, Your Lordship.
Huh?
Sanjita Roy's case, Your Lordship, this is.
There is a judgment of this court also.
Lordship.
Find it out.
And
What do you have the law? You do have the judgment. Are you relying any judgment?
Lordship, this is recent judgment, Your Lordship.
Yes. Heard Mr. So and so, learned counsel for the petitioner. It's a 2017 matter.
Lordship, a short date may be given.
Recently, Lordship, one case has been decided in the division bench of Your Lordship in WR number Lordship, 133 of 2023, Your Lordship.
Lordship, against that, we have filed an IA,
IA
which was disposed of, and we
Disposed
are
of.
contemplating, we are preparing a review against that said IA order.
No, so long as it is not
Yes, Lordship.
reviewed.
Already they have filed an IO that has been also been disposed of
Yes, now we are,
in favor of Lordship petitioner.
IA.
Yes.
yes, the IA,
Lordship, copy I have not Lordship short petitioner.
What is this here?
Long. Recently, Your Lordship, I have seen Your Lordship 24.
Why to grant a relief? There is judgment of this court also. You are not ready. Heard so and so on the prayer of Mr.
AK Ghosh,
A.K. Ghosh
on behalf of Mr. K. Kaur.
appearing on behalf of
Mr. K. Kaur.
K. Kaur, London Additional Advocate General,
Yes, Lordship.
Additional Advocate General appearing in this matter. On the prayer I said, on behalf of so and so, and Additional Advocate General. On the ground that the additional AG has some personal difficulty today. Better is adjourned. Hopefully the fact that the learned counsel for the petitioner is not prepared with the brief, with his brief. List after 4 weeks.
Can it be
It is-
possible
it is-
before vacation, Lordship? Any day?
Huh?
Before vacation? Any
4
day,
weeks, it is made clear that no further adjournment shall be granted in the next day.
Obliged, Lordship.
Lordship, I'm appearing on behalf of Accounting General R.K. Talukdar.
May it please your Lordship.
Yes.
Lordship, may kindly pass it over for the time being, Lordship. I
Why?
appear for the APGCL, Lordship.
Hmm.
Lordship, Mr. Deenath will be appearing in the matter.
What is the matter?
Lordship, I'm appearing for the item number 3, Your Lordship.
Hmm.
Lordship, today my senior counsel will not be able to appear because he's out of station to Manipur. His mother-in-law expired. So may next day be fixed for item number 3 and 4.
Senior counsel,
Yes, Your Lordship.
who?
BD Core, Your Lordship. As per
On the ground that Mr. Bidiko, learned senior counsel, Bidiko, learned senior counsel, appearing in item, writ petition, WPC 3410 of 2019, is in bereavement. MS so and so, learned counsel, appearing on her behalf, on his behalf, as prayed for adjournment of the matter
Lordship,
to 4 weeks.
Lordship, in item number 4, I am appearing for APGCL, Lordship. We have not been served with a copy of the petition. Lordship,
You are-
kindly recorded, Lordship.
Your Lordship, I am also in item number 4. We have not received the copy, Your Lordship.
Lordship.
And for item number 3, Your
Who
Lordship.
is I for item number
Similar
3?
matters, Lordship.
Similar matter.
4.
Lordship.
Anyway,
Your Lordship,
they are
regarding-
not being opposed by the learned counsel for the respondents. This matter after 4 weeks. Yes,
Your Lordship, regarding item number.
nobody
3,
is there, item number
Item
4,
number 3, our name has not been shown. Sending counsel AGCL. Your
APDCL.
AGCL.
The rest to reflect the name of the learned counsel
AEGCL.
for ACG,
AEGCL.
AE,
GCL.
GCL. In the
Lordship,
court
may
list.
record Mr. Deenath's name, Lordship.
Huh?
For Standing Council APGCL, Lordship.
Ah.
Deenath, Lordship.
Then you write. You write, prayer not being opposed by by Mr. Deenath and
K. Fukan.
K. Fukon, learned counsel for the APDCL, AGCL. and-
AEGCL.
You give your name.
Okay.
Yeah, so and so, huh?
Yes, Your Lordship.
Got it? You just record your name. that's all. Yes.
My lord, the case relates to my lord promotion from junior assistant to senior assistant, my lord. So prayer is to mandamas petitioner to entitled for promotion. Their case is, my lord, so we cannot be promoted from personal post. But before that, my lord, there is a, my lord, suitability test was done, and accordingly we are selected. We are holding the post for last 18 years, grade 3. So our cadre post is grade 3. From that, we are entitled. Now they said that your regularization in personal post, you have no way or option to be promoted. That is their case. Now, there is that way. When we are selected for promotion, they have filed a private respondent and filed a writ petition. There is an interim stay, and that is why our promotion is not affected. After that, he got managed the promotion, he withdrew this case. But because of the pendency, we are not promoted in spite of the post of senior assistant is there. My
Why
lord.
this, you are for?
I
Both.
petition. I am both of the cases, my lord. One is already retired, that is the Purnima Roy, 5 number, 6 number, 5 number. He is still there. And that is.
So you are not pressing by item 6.
Both are 6, my lord. Sir, her entitlement be declared, my lord, but she may not get promotion, my lord. She is already in purchase.
In fact, it is a settled law, Lordship, Lordship, from the post of personnel, there cannot be any promotion, Lordship.
And
If somebody is promoted, Lordship, she is wrongly
we'll-
promoted, Lordship.
my lord,
Close this item 6, edit structure.
She has come after retirement, Lordship.
no, not retirement, before retirement, my lord. When
When did you retire?
we retired, my lord, 20, my lord, after pendency, during the pendency, she was retired.
Lordship may
When
she-
she filed, she was not retired, my
In
lord.
any case, we cannot direct for promotion.
Yes,
Yeah,
that is
correct.
fine.
So we're,
But let
we're
me-
closing it.
My lord,
We'll take it, we'll hear the item 5.
yes, first high, my lord.
6, we are closing it.
My lord,
All right.
yes, my lord. So,
Heard Mr. MJ Barua, learn counsel for the petitioner. And Mr.
N. Upadhyay,
Anupadhyay, learn steering counsel,
Irrigation Department.
irrigation department,
I'm for respondent of pipeline scheme.
and Mr. SK Medi,
Sending on to easy on accountant.
steering counsel, accountant general, and
Number 4, finance department.
we just write all this here. Last will be not N, comma, and then N, last one, Mr. MJ Barua, next pair, learn counsel. Submits that since the petitioner has
already.
already retired from service, the writ petition will become infructuous. Right?
For our pensionary benefit, we can claim.
We cannot direct now. We cannot direct. Please step accordingly. The writ petition stands closed as infructuous. Right? Item 6.
Items.
Yes, come to item 5.
Item 5, my lord, page 21. This is the service book, my lord.
Yes.
Here it is written in page 22. So this petitioner was appointed in 86, 17/11/86. Because the department has some sanction post, but because of that ban or something,
21 is what? What is this?
21 is service book, my lord. Your lordship, I want to point out, your lordship, the page 22 is to note only to show that when she is appointed and when is regularized and when is promoted to LDA. This much, my lord. Have a look, just a minute.
Regularized on 22/7/2025.
Who was engaged as MR labor in 17/11/86. So from 86, this petitioner has all the qualification. She is high secondary and typings that she is conducting the service of ministerial staffs. Although when regularized, she was regularized as grade 4. So why there is a ban in Assam? That is why probably this promotion or regulation was not done.
And
But
promoted on
on, my lord, 22/7/2005.
LDA. No.
My lord.
Regularized as helper.
Yes, yes.
22/07/2005.
Yes.
And then they
Then,
are
my lord,
claiming the first for
promotion, she was LDA come typist.
Yes.
Promotion. It is in the year, my lord, 2000, my lord, say 8. This is a service book. My lord, so my lord, just have a look, my lord, page 29, annexure B, that is the.
just wait. Regularized is helper. Yes,
Then, my lord, 2008, she was promoted to
Promoted.
LDA.
LDA.
Her promotion to LDA is undergone the suitable test. She has undergone suitable test. My lord, she pays 30, 30, 32, my lord, page 32 and XR C.
Hmm.
She has been all along discharging the ministerial staff's post, although she was regular in grade 4. So, to fill up this sanctioned vacant post, some procedure is adopted. That is the, my lord, the
Vacant post of what?
my lord, the typist grade 3 colleagues. Although regulars in grade 4, but
Directed to improve for filling up the existing vacant room.
Yes,
Check the
sanction
application of eligibility candidates are required to be submitted to the superintendent. In this case, we are requested to forward the application of eligibility. This is what?
this is the
This is for what?
this is for this is for our interview. This notice was circulated through our
Or what? Which post?
for grade 3 post, sanctioned grade vacant.
LDA.
Yes,
LDA.
LDA.
When you have already regularized
I am
after this only.
my lord, this post was vacant since 86, but when we adopted engaged, then we are
86, you are master role worker.
yes, but we are discharging
And
the-
your service has been regularized as a helper on 2005.
my lord. Now this
And then promoted on 2008.
then my lord, they conduct an interview, my lord. All after circulations, everybody has
After the promotion.
yes, from grade 4 there is a scope to promote to LDA eligible if they are eligible. So that is why there is
Sir,
a
you have already been promoted
not
as
promoted.
as a LDA.
No, my lord. After that, we are regularized. But here, my lord, the service book I have seen when we are promoted. But here I have seen, I understood that how he is promoted. She is promoted to LDA, my lord.
Yes.
Due process, by due process, my lord. And
It's okay.
Yes. Then, my lord, this is a minute, my lord.
It's okay. You have been promoted as LDA
Yes.
after due process of selection.
Yes, my
That's
lord.
all.
Okay,
then
my lord, we are working there as LDA with discharging our duties, and garrison list also prepared. My lord, what happened, my lord? In the meantime, my lord, some of the master roll workers, they challenge our promotion.
Yes.
Before this court,
Yeah.
honorable court, my lord. They are not qualified because they are metric or, but since they have not given chance, that is why they challenge. And my lord, page 45, annexure G, is this writ petition, my lord. I just want to give the history of this case, my lord.
That history.
My lord, what happened? The honorable court has
Yes.
has directed to revert back only on the ground that
Including you.
yes, not me. This petitioner is promotion is not challenged. That is why they are kept out of. In this order itself, it reflects that as regards this petitioner is Rukmini Gao, serial number 14, page 58. Kindly see, there is no serious challenge. That is why their promotion is not.
Where it is, where it says.
Page 58, my lord.
Pera. However, I am not interfering with the promotion of private respondent to 14, 15.
14 is kindly see, my lord, page.
You are 14.
Yes, page 45, kindly see Rukmini Roy. Page 45, I'm a respondent number 14.
Okay. So only on the ground their appointment orders have not been challenged in the written. Yes.
So by
Okay, then-
promotion is intact, my lord.
Yes, then
Then, my lord, what happened? The petitioner also approached this division bench. Division bench says that page 68, my lord, kindly see this, either to take initiative fresh selection or to take a decision on their regularization, because they are already 6 years they are working within 3 months.
finding recorded by silencing that absolutely having regularization did not have sufficient light of information, it could not be shown to be actually erroneous. However, it was submitted applicants had long service as master law and known that this is they considered eligible. It is not the case of any donation. Yes,
Yes.
your whatever the appointment and regulation, this was held to be against rehearse the rule.
Yes,
By
because
the
three,
division
three
bench.
counts, my lord.
It's
Seniority,
okay.
merit-
No, that then
Yes, yes. Now, my
we
lord,
dispose appeal with direction
yes, yes,
instead
they have,
either initiate price selection so and so.
Yes,
Then
yes.
thereafter.
that fresh selection cannot carry it out, and even there is no decision of regularization my last 13 years, my lord. Kindly, why the reason is kindly page 69, C class, page 69. This is the communication, my lord.
Yes. So
Here, there are altogether 13 LDA in the division. If they are demoted, then the whole department will collapse. Admittedly, from 86, they are discharging the function of LDA, although not regularized or promoted. So to fill up the vacant post, they adopted some procedure that was challenged on the ground that in law there is seniority come merit, but here merit comes seniority.
no,
on that-
no. How can you have a decision by the department without the over and above the judgment of this court?
Yes, the judgment is clear. Either you initiate a fresh selection or you take a decision of regularization of this petitioner, my lord.
Yes.
That too should be taken. Now, why they cannot take it? Because this communication is clear. They says that there is no grade 4 post to which they should be reverted back. That post was abolished because when the regulars, that post was grade 4 personal post, that is abolished. Now, that is two difficulty. One difficulty is that there is no grade 4 post existed so that they can be reverted back to
Where it is? Where it is?
Page 70. Page 7.
Yes. Then they
Then,
could
my
not do
lord-
anything.
My lord.
They did not do anything.
Yes, my lord. Now, after 3 months elapsed, they are continuing. They are also silent because there is no post. Now, this is very important that they are the feeder cadre is grade 3 LDA. Because of their action and because they are now LDA, they are for last 18 or 23 years, they are LDA. 2019 senior assistant UDA post vacant, they are also eligible for that. Graduation list was
It's
prepared.
okay, but then what happened now? What do we want? Then
Then, my lord,
you have been allowed to continue. You have not been reverted.
reverted, and they have not taken the fresh selection also. And because
Now,
now they are in LDA. Now, when the graduation list was prepared, our name is 1 and 3. Page 74, kindly see. Rukmini Roy now petitioner of 5. Case number 5, petition number 5. She was senior. Now, one junior challenged the graduation list and their promotion to UDA. They think that he is eligible for promotion. Accordingly, ex parte orders place 77 that was passed by this honorable court, and their promotion is halted.
yes.
Now, my lord, after page 78, what happened? Somehow the private respondent got promotion in pendency of this case, and this become infectious. And page 71, he withdraws the petition, his petition, my lord. But 78 is his promotion order, the private respondent promotion order. That is the Deepak Kalita.
Yes, he has withdrawn it.
Then he withdrawn it.
Now-
Now we are that is why we file this present writ petition seeking our entitlement, declaring our entitlement. We are senior. Why should not we give promotion? Now, lot of post in UDA is vacant, but because of this pendency of the writ petition, we are handicapped. Now,
So you withdraw this, and
My
if
lord.
that is the case, you withdraw it. Shortcut, they will consider.
no, my lord, but that should be adjudicated because they file affidavit. They said that personal post.
See, problem is created by you and the government. Court has clearly said that your appointment was diverse the rules. You could not have been. There is no relaxation.
Promotion, Lordship.
Promotion.
Promotion,
Your promotion.
Lordship.
Right?
Yes.
And the liberty was given to the state to take a fresh call
Yes.
for appointment. That has not been done. So your appointment, in fact, is not an appointment or promotion as such. It doesn't stand legally today.
Yes, in
So unless you are in the legally, your appointment is accepted as a valid appointment,
Valid
right?
promotion, Lordship.
valid promotion.
Lordship.
You
Madam,
cannot. How
I
you
understand.
are seeking for senior?
yes,
Now,
I'm senior.
You are no, you are seeking for senior. What is
now
called?
she is asking for Lordship UDA, promotion to the UDA, Lordship.
Upper the
Upper Division Record.
Yes, now question here is to adjudicate whether my
Lordship.
feeder feather is LDA or not.
until you are not legally, you are not practically, you may be. So first get your the promotion in LDA corrected.
Yes. So,
Legally. Practically
legally.
you are working, so we cannot correct it because
Correct.
there is a division bench judge. Division bench, there is an observation
yes.
that there is no relaxation. You have been appointed. There is, what is the division bench judgment?
No,
Page-
division page, my lord,
68.
no, 17, 9, 7, sorry,
68.
68, my lord, yes.
You come to para 67.
Yes.
The
60.
finding recorded by the London single judge that appellant having been regularized in 2005 did not have requisite length of service or eligibility for promotion of grade 3 could not be shown to be factually erroneous. However, it was submitted that the appellants had long service as master role employees, and on that basis, they will be considered eligible in the light of circular so and so, so and so. It is not the case of the appellant that any relaxation was made in the eligibility requirement pointed out in the order of learned single case. In the absence of relaxation
My lord.
of the
That-
requirement, the rules had to be followed and the appellants could not be appointed in violation thereof.
My lord, my humble submission is this, our learned advocate has not submitted there is a relaxation. It was the case of relaxation because residency period should be
It's not only, it's not about your promotion. It's your initial regularization.
Yes, yes.
Route has been cut.
Now they are,
So the branch is bound to fall.
yes, now they have to take decision, they have not.
Yes, if that is yes, so it's a question of promotion. Very unfortunate.
My lord, page 32 kindly.
Very unfortunate for you.
In case of.
Your regularization itself is not valid
My lord. My lord,
as per the observation of the division bench.
Division bench.
but they have
But
to-
then there was a liberty was granted to the respondent to consider it afresh,
or,
whatever.
my lord,
That too, not in the post of LDA. It's in the post of
Grade 4.
grade 4.
grade 4 again regularized, my lord, what is the question of
Well,
again?
see, look at this order, page 67 and 68.
Yes.
Your the initial challenge was about this
LDA.
grade 4 only. No.
No, my lord, how can it be? How can it be? Our grade 4 regulation is not challenged, my lord. We become LDA in 2007, 8, my lord. Because residency service should be 2 years, 5 years, it is 2 years, that is relaxation, and the relaxation
In the-
which was not submitted.
In the writ appeal, Lordship, the writ petition was in the respondent side, Lordship. Because she was the respondent here, respondent number 6, page 59.
Okay. Yes. Well, is a single bench, the thing, single judge order.
Yes, single bench order is, my lord, page 58, and my lord, it starts from page, my lord, operative parts 51, my lord. And here single bench, honorable single bench says that we are kept purview from outside purview of this order because there is no serious challenge to this petitioners. Promotion. And their challenge to LDA is only two counts. One is that there should be merit come seniority should not be, it should be seniority come merit. Because in rule, there is no mention of the suitability test. Only senior should be given promotion. On that counts, court has take judicial notice and says that these petitioners, the junior masteral workers and some seniors as approached, they should be considered first. They are not eligible. That is why they cannot fill up this post.
Why?
On the space, rule is page 54, my lord. Rule 9. That is the rule.
Ministerial
Yes,
specific
yes.
establishment service rules.
Yes, my lord. This is the rule.
Okay, challenge was for LDA.
LDA, my lord.
Okay.
By selection on the basis of seniority come merit. Here, merit come seniority given.
Page where it is.
That is the yours.
Page.
Page 54, my lord, B, 9B. By selection on the basis of
You are reading from the judgment.
Yes, yes. That's
Huh?
page 54, my lord.
You are reading from the judgment.
From
Yes.
the judgment, Lord.
The election
rule
code
is with
after
me,
entering
rule
the
is
improvements
with me.
information from self-improvement for the actually. Where is the lower division assistant? Why you have not been, why you are not eligible?
Because they says that the 7 years residency period should be in grade 4.
Where it is?
We are regulars on 5 and 7. How can we be?
Where it is?
My lord, this rule says, my lord, by selection on the basis of seniority come merit from
B,
among the
B.
grade 4 staffs
6B, Lord.
of the district establishment.
6B.
Lord.
Yes, page 54, last paragraph.
By selection of the basis amongst grade 4 staff district who had passed their
Rendered
selection is made. Where is the qualifying years?
7 years is written there, have rendered.
Rendered at least 7 years. Yes.
Yes.
So
Now-
this you are not fulfilled.
Yes. Now, my lord, they are from 86 continuous service. And
Forget about that.
my lord, there is relaxation, my lord. It is on our part to not to point out these divisions, honorable division.
Where
bench
is
that-
the relaxation?
My lord, page 32, my lord. 34, my lord. 34 and 32, kindly see, my lord. This is the notice. There is a relaxation clause. Last line, my lord. That was not pointed out. Unfortunately, our learned advocate, my lord. The court has rightly says that you have your case is you have not projected your case.
Where it is?
My lord, including newly regularized grade 4 staffs. We are newly regularized grade 4 staffs, my lord. It was mentioned. We are also included. And this is not challenge, my lord. In respect of you are
Where it is? Where you are reading?
my lord, regularization of the service department staffs. So page 32, my lord.
Second paragraph, page 32, second paragraph. In this respect, you are requested to forward the application.
What do you mean by this?
And last paragraph, my lord. In this respect, you are requested to forward the application of eligible candidates, including that is the exception, my lord, relaxation.
What do you mean by that? Very strange.
Newly regularized.
How the rules are relaxed? How the rules are relaxed?
They are given because of
What is the procedure for relaxation of the rule?
My
Number one, there must be a provision for relaxation.
Yes.
Number two, how it is relaxed?
Because
It is not by the letter.
Yes.
It is by the state
The
who,
department
the
will say
authority
that
who will
that-
relax.
Yes, my lord.
By
Uh,
giving a reason why the rule has been relaxed. Then
Then-
only that is called relaxation of the
yes,
rule.
Page 56, kindly see what department has said, my lord. Department,
Saying is not enough. There must be some decision to relax.
and it should be challenged, my lord. It should be
It's
challenged.
not a
Says that-
question of challenge, question of your valid appointment or promotion.
Yes.
Court has observed, okay, I was wrong when I said that the grade 4. Grade 4 is not an issue now. Grade 3, your appointment, the rules require that 7 years minimum, right?
Yes, yes.
Then you are promoted before the completion of, without the complete 7 years.
Yes, then direct
Qualifying,
recruitment,
yes.
in direct
Then
recruitment,
that's why division bench said that there is no relaxation
it is
also.
not a case of relaxation.
No,
We cannot project our case in the case of relaxation, although it's a case of relaxation.
it's
that was-
not a question of you are saying you are projecting. It's a question of whether your rule has been relaxed or not.
Yes.
Admittedly, there is no relaxation. Your consideration
Yes.
deholds the rule cannot be presumed to be a relaxation of the rule.
Yes.
That's what I'm saying.
Hello.
What is the provision for relaxation? Number one, if there is a provision for relaxation,
Hello.
a decision has to be taken to relax the rule, particular rule. In your case, 7 years. Then only it can be treated or it is accepted as a relaxation of the rule. Otherwise, rightly the council who has appeared has not pointed out because there is no relaxation.
But at
You
that time, my lord-
you cannot blame him. He
Yes,
could not have
I
Sunday
understood, my lord.
when
That
there
is
is no
why-
relaxation.
That is why Honorable Division Bench right.
So your appointment or the promotion is deholds the rule.
Yes, at that
Now,
point
on
of
that
time.
basis, whether you have been allowed to continue or not, we're not concerned. First, your appointment as the promotion as to the post of LDA has to be valid. Then only you can claim for further promotion.
Yeah.
Correct.
Yes.
That is why, my lord, Honorable Division Bench says that already our residency process is completed. That is why taking
So
consideration of
the
that-
division bench has for only to consider your case by a fresh decision.
Yes, when fresh decision taken, we have already completed 13 years, my lord. That
Where is
residency,
the fresh
but
decision?
the fresh decision they have not taken, my
So-
lord, keep the pending.
It is
that- A fresh decision is taken in.
your ill luck initiates a
No,
fresh
my lord, it
process
is a
or
pick
take
and
a
choose.
decision on regulation in accordance with the rules. Where is
So-
the decision?
My lord.
Otherwise, if there is no press selection process, decision should have been taken.
Yes,
If you cannot be rebutted back,
yes.
then that has not been, you have not get it done for you. Who else will do for you?
Yes, my lord. In next item, my lord, that was a
Next, I
regular.
think already.
Yes, that regularization was done in her case. In this case, regulation not done. More particularly, her promotion was not also challenged, my lord. As honorable court has kept her promotion.
That is
in-
finished. You don't rely on that.
No, no, this case, item 5.
So,
So my submission is that her promotion to LDA is not challenged. Its honorable court has kept herself in purview of this order. To
you have filed the appeal, writ appeal you have filed.
No.
Division bench,
yes,
you have filed a writ petition, writ appeal.
read the appeal.
It's on your own writ appeal only this order was passed.
Yeah.
So,
Now, my lord, at this stage, my lord,
what?
this they have the responsibility to take something. Otherwise, how can they take out our rights, my lord?
Yes.
Lordship, we have filed our affidavit, Lordship.
No, you just tell us.
Lordship.
When the court has given you a liberty to take the decision for regularization, because you have admittedly said they cannot be rebutted back, though the court has held their appointment to be deholds the rule,
Lordship.
not in terms of the rules, indicates that it's one of the valid promotion or appointment,
Lordship.
right?
Lordship.
All right, wrongly, rightly. then he has shown some your communication of the chief engineer, saying that due to, the heart of the the officials, they cannot be rebutted. 13%. What should be done? You could have taken a decision because division bench has said either you initiate a selection process or take a decision. Right? Clearly said, initiate a pre-selection. We dispose the appeal with direction that the state may either initiate a selection process or take a decision regularized in accordance with the rules within 3 months. This could have been done. You are simply saying that they cannot be rebutted. You could have relaxed the qualifying years, right?
Not question of qualifying, yes, Lordship. In fact, Lordship, they were appointed against personal post, Lordship.
It's all right.
Yes,
What
Lordship.
division bench has said, you have not done, and you said that they cannot be rebutted back. What do you mean by that?
The post already abolished, Lordship. That is the reason, Lordship.
Which abolished?
The grade 4 post, Lordship.
Grade 4 post? No. Now it's a grade 3 only.
Lordship,
Grade 3
they
grade
were
3 is a
they were not reverted back only because, Lordship, there are no posts to revert back them, Lordship. Already abolished, Lordship.
in which post?
The grade 4 post, Lordship.
Yes,
Yes.
you have allowed them.
That
The
is why,
challenge
Lordship,
was to the LDA only. Single bench in her case did not interfere because it was not challenged. Now division bench
my
has
case is,
observed
Lordship,
that
though she
it
is
was
not, Lordship. My case is, Lordship, our case is, though she is not entitled to get promotion to the LDA, Lordship, wrongly she has been promoted. And the post she was holding, grade 4 post, that was abolished, Lordship. Now, Lordship, on the basis of wrong promotion, she is asking for further promotion, Lordship.
no. The division bench, the issue was regarding LDA only,
Lordship.
not the grade 4.
In fact, Lordship, the division bench of our code, Lordship, clearly says, Lordship, the personal post was.
Sir, you have to first establish what is the personal post. Wrongly or rightly, grade 4 is out now. Grade 4 you have regularized. There's no issue. Nobody questioned that.
Regularized against personal post, Lordship.
Okay.
And they are not entitled to promotion to the next higher post, Lordship.
Again, in which post? LDA is a personal post.
No, Lordship.
Then?
The Lordship, yes, Lordship. That is, I am saying, Lordship, wrongly they were promoted, Lordship. Now, Lordship, on the basis of wrong promotion, they are asking for, Lordship, further promotion, Lordship.
No, division bench has said, a single bench said it is against the rule, not because of the personal. Their promotion was held to be not in accordance with the rule because they were not eligible. Less than 7 years qualifying survey, right? Then division bench said it is correct. The finding is correct. No, we are not going into it.
Lordship.
You show us that the LDA is a personal post.
Lordship, LDA is not personal post.
Then,
LDA is not a personal post.
if it is not personal post,
but Lordship, the post she is holding, the LDA post.
Yeah, where on the LDA only, not for the helper. Helper may be a personal post.
Lordship.
Wrongly or rightly, you have promoted.
Lordship. That is
What the court has observed is that since they are not eligible to be promoted to the post of LDA as per the rules, therefore it was illegal. But then it was not interfered. It has not been interfered so far as our case is concerned. Now, division bench also accepted that promotion to the post of this was illegal, not proper, because it was against the rule, not as per the rules. Because why they are talking about the relaxation? Because they are not eligible. Qualifying, they are not having a qualifying years as per the rules, right? Now, ultimately, division bench has directed and given you a liberty to either initiate a press selection or take a decision on regularization. You have not done. You simply say that they cannot be rebutted back because there's a dearth of officials, right? So at this point, how can you go back to those personal posts of grade 4? Why not? He's just asking for a regularization in the personal post.
But Lordship, the thing is, Lordship, kindly see my affidavit, Lordship.
What affidavit?
Paragraph 9, page 84, Lordship.
Yes.
That as regards to the statements made in paragraph 15 and 16 of the writ petition, the answering respondent begs to state that the writ petitioner was promoted to the post of junior assistant from personal post of helper, and his service as junior assistant has not regularized till date. Her post is not regularized as grade 3 lordship. Though she is doing the work of a grade 3
Court
lordship.
has not interfered his promotion. As a grade 3. Single bench.
Yes, Lord.
Single bench has held that promotion or to the healthy was wrong because it's against, I mean, they heard the rules. But then, since the promotion order is not under challenge, right? It was not interfered with. All right. Now they approach the division bench. Division found that all the appointment was, promotion was against, not in accordance with the rule. Therefore, directed to you to initiate either a fresh selection process or to take a decision on regularization. As on today, it has not been done. But can it be allowed? Your own showing it says that you don't want to revert them back. Right? Or you are not taking any decision. They cannot be, and you are utilizing her service. You take a decision.
Lordship.
Considering all this.
Lordship.
So we cannot direct for promotion.
Yes.
After the decision in the post of LDA only, your claim will emerge.
Lordship.
You request them to regularize from the date of your
Yes, I filed a representative.
from the date of your eligibility or whatever.
Yes.
And I think you should regularize them.
Yes.
Take a decision to regularize them from the date of their eligibility. Say 2000. Add 5 more years.
He will retire next year, my lord. I have 30 years is serving, almost 20.
You cannot help it out. No one
So
can.
they should take a considered decision with a representation.
Yes.
That
Heard Mr. MJ Barua. Michael Jackson. Learn counsel for the petitioner, one petitioner, right?
yes,
One petitioner. And also had Mr. D. Upamanya.
N Upadhyaya.
N. Upadhyaya, sorry. N.
1, 2,
Upadhyaya.
3. 1, 2, 3, Lordship.
Learned standing counsel
Lordship.
for
Respondent number 1, 2, and 3.
higher secondary standing counsel for
Irrigation, Lordship.
irrigation department
Lordship.
for respondent number 1, 2, and 3. What about 4? 4 has
Lordship.
also retired.
He is already promoted, Lordship.
Okay. You are not challenging his promotion. You are not challenging his promotion.
we are challenging that his promotion, but he has already retired and withdraw that case, and we also challenge that, my lord. There is
Here.
also, my lord. There is, my lord.
He has retired now.
No,
No.
retired. He's got promotion. He's got the benefits.
So you are not interested.
I'm interested, but I have challenged at that point of time. My prayer is there to pass and cancel this promotion order also.
Service is affected. Service affected.
Affected, my lord.
Where? From where would you say? Okay. None appears for the none appeared for respondent number 4, despite the despite notice is effective. Huh? Next pair. By filing this application, the petitioner has quickly challenged the order dated 21-10-2020. Where this, there's that order 21-20? 78.
Yes, my lord.
Ah. 21-10-20 issued by this executive engineer, Dhubri district, Dhubri division, executive engineer, irrigation department, Dhubri division, Gauripur, Assam, by which the petition, the respondent number 4, Sri Deepak Kalita, along with one person has been promoted to the post of senior, what is this?
Senior assistant, my lord. It is UDA or senior assistant?
Promoted to the senior assistant. The petitioner has also prayed for it. Direction to the respondent authorities to promote the petitioner in the post of senior assistant. Next paragraph. The briefly put, the case of the petitioner is that he was appointed as master roll worker,
Yes, ma'am.
on
86.
17/11/1986, and thereafter his service was regularized on 6/10/2005 in the post of a helper, along with some other persons.
Yes.
Along with some other persons, as per the policy decision
Yes.
of the state in the year 1983, taken in the year 1983. Mr. The petitioner was appointed, promoted further to the post of, what do you call? What do you call it?
LDL,
LDL,
Lord Division Assistant. LDL.
LDL, Lower Division Assistant,
Now it is junior assistant.
Or oblique GA.
Public Junior Assistant.
Yeah.
Huh? From typist with effect from 01/08/2008 in the grade 3 post. A grade 3 post. After due process of selection. Mr. Next paragraph. Along with so many, how many persons? 2.
My lord.
Where is your selection?
My lord, page 35.
Promotion?
Promotion, selection is page 35, my lord. This 10-11 was sorted out, my lord. And our
Out
promotion,
of that, how many? Along with? Where is the appointment on? 3 persons,
3 persons, yes, 3 persons.
along with 2 other persons. List of. Next paragraph. The selection and appointment of the petitioner and other 2 persons and other persons similarly situated were put to challenge by some. They were grade 4 employee. A grade 4 employee.
Master roll. Oh,
Master roll Who has challenged that?
Yes,
Master roll worker.
master roller.
Some of the master roll workers.
They are senior in grade 4 to petitioners. They challenge.
Who claims to be senior
Yes.
in the grade 4 by way of writ petition before this court being WPC.
See,
Batch of writ petitions, huh?
Yes.
5 writ petitions were
Five-
there.
One is 549 oblique 10,
Leading case,
page 45.
leading case being WPC 5492 of 2010.
5493 of 2010.
No, first one is
Lordship,
two.
Lordship.
Page 45.
Lordship.
Mr. The writ petitions were disposed of by common order dated 13/09/2011. So and so dispose of, huh? What I said last one. By allowing the writ petition, there were set aside some of the appointment orders of the respondents. Mr. Bhava, the promotion of the petitioner and 3 others had not been interfered with solely on the ground that their appointment orders were not challenged in the writ petitions. Mr. The learned single judge found that the appointment of the respondents in those writ petition, including the petitioner, were found to be not in accordance with the rules. We have not annexed the rules.
My lord, rules is with me, my lord. I have not annexed, but.
What is the name of the rule?
My lord,
Namely, the Assam Ministerial District Establishment Service Rules 1967. It's the aforesaid order passed by learned single judge dated 13/6/2000. No. What is that? 30? 13/9. Was taken to appeal on by the petitioners who has filed the appeal.
appeal page.
Where is your name?
Respondent number 6, Lord.
No, no, in the appeal, writ appeal.
Writ appeal, Lordship, series respondent number 6.
No. Read appeal.
59, page 59.
You are not you have not filed an appeal.
Because in the report, my lord, my name is not interfered.
No. Taken to appeal by some of the LDA junior LDA or JSA. LDA, huh? Now LDA so now redesignated junior assistant. What do we call it?
LD or junior assistant law?
Juniors.
Lord.
Being WA number,
301.
301 of 2011. Three zero three 327. Division bench by the order dated 13/06/2012. Dispose of the appeals with the direction that the state may either initiate a fresh selection process or take a decision on regulation in accordance with rules. It also provided that since the appellants have been continuing for more than 6 years, pending decision by the state, they may be allowed to continue as adopt arrangement. You are not the appellant also.
No, my lord. That is I annex, but that observation may be.
It is also noticed that the division bench has clearly held that the it has not interpreted, has accepted, upheld the finding recorded by the learned single judge that the appellant, having been regularized in the year 2005, did not have requisite length of service or eligibility for promotion to grade 3. Which could not be shown to be factually erroneous. It also reported that the case of the appellants is not that of any relaxation was made in the eligibility requirement pointed out in the order of learned single judge. And in the absence of relaxation of the said requirements, the rules had to be followed and the appellants could not be appointed in violation thereof as has been done. Just said, let us say 67, page 67, 68. Any confusion with that? Division no. Next page. It is admitted, no, the next page. Mr. M.J. Barua, learned counsel for the petitioner, submits that since the promotion of the petitioner dated 01/08/2008 has not been interfered with by the learned single judge, has been allowed to and the petitioner having been allowed to consider, continue in the said promoted post of LDA of the JSA, J, comma, by now the petitioner has served, has been serving the department for more than, by now, from 2008.
Since 2008 to 2025, 8 to 25 to 13, 2008, his promotion is 2008,
17 years,
17.
more than 17, nearly 17, more than 16 years.
Yes, more than.
List of, comma, the petitioner is eligible to be promoted to the post of senior assistant. List. He submits that although the division bench, although this court has held that the appointment of the promotion of the petitioner was not in accordance with the rules, applicable rules. There was no interference to the promotion of the petitioner, and division bench having been directed to take a decision on regularization of the appellants in those writ appeals. The
Appellant, Lordship, petitioner is not the appellant.
yes, and that's why I said that.
Lordship.
The authorities ought to have taken a decision either to initiate fresh selection process or to take a or on a regularization of the incumbents. Mr. Next paragraph. No, Mr. While referring to the various communications made by the respondent authorities, Mr. Borwa and counsel submits that the petitioner has not been rebutted back even after, and he rebutted back against today, rather is continuing. Therefore, he submits that the respondent authorities may be directed to consider the case of the petitioner for promotion to the post of senior assistant. Mr. Borwa, learned counsel at the time of hearing. No, not at the hearing. Fairly submits that. No, not fairly. He submits that. Although initially he has challenged the promotion order of the respondent number 4 to the post of senior assistant by left of the petitioner would not press the challenge to the promotion of the respondent number 4. You are not challenging now.
Well, page 19 prayer is there to cancel.
Prayer is there that I have recorded. You are not pressing now. We cannot interfere, wrongly or rightly.
Well,
Because your promotion in the
yes.
LDA is
still
under cloud.
Yes, in their hand, my lord. So there should be a direction, my lord, on your left for
Next para.
on your left.
On the other hand, Mr. The and Upadhyay, learned standing council, while referring to the para 9.
Para 9 and 12.
affidavit in opposition
Para 9
by
and
the
12.
respondent authorities submits that since the petitioner was promoted to the post of junior assistant from a personal post of helper, and her service as junior assistant has not been regularized till then. He cannot claim for promotion to the post of senior assistant. Then
12 plus similar lawsuit.
you are not saying that you cannot be. What you are saying is your personal post was the helper.
Law says so, lawsuit.
No, no,
Lawsuit.
you have not said so. We are not for this thing. We are not going back.
Lawsuit.
We are not.
Lawsuit.
Let us not distance that too far back. All right.
Lawsuit.
You have not also said. Para 4, you have said the facts you have told.
Lawsuit.
You have stated the facts. And para 12, what is this? Petitioner original post was a post and she is not regularized in the promoted post of the till then. No, there is the same thing. He submits that since the initial, feeder post of helper was a personal post and her post in the junior assistant having not been regularized, the petitioner is not entitled even for consideration. Till that, you're right, till that, she's not entitled to consideration for promotion to the post of senior.
Next higher post, lawsuit.
You want to rely there?
Lawsuit, this is
Why you
lawsuit.
want to rely?
This is basically lawsuit grade 4, from grade 4 to junior assistant lawsuit.
No, that's not the question.
Lawsuit. That is not
Right.
lawsuit.
Well, not let us not make
Lawsuit.
it.
It is already gone lawsuit.
I have due consideration has been extended to the tribal submission of land council for the parties and also queries the materials available on iPhone. Admittedly, the petitioner was admittedly the petitioner was appointed engaged as master roll worker in the year 1986. Mr. And subsequently, as per the policy decision of the state on regularization of master roll worker, the petitioner was the service of the petitioner regularized as helper in the year 2005.
Right.
Thereafter, the petitioner was promoted to the post of junior assistant by dated 01, with effect from 01/08/2008. Next paragraph. It is also admitted position that the appointment of the promotion of the petitioner to the post of junior assistant was put to challenge before this court. Wherein by an order dated so and so single bench, the appointment, the promotion of the petitioner and other similarly situated persons who are held to be not in accordance with the rules of so and so, 1967. However, the appointment, the promotion of the petitioner along with 3 others who had not been interfered with solely on the ground that the promotion were not challenged. Some of the response while then writ appeals being so and so, write all those writ appeals. Whereby a division bench of this court by an order dated. What is the order?
Page 60.
Order dated lordship 13/6/12.
13/6/2012 has upheld the judgment and order of the learned single judge. Judgment order of the order dated sense of the learned single judge, and well dispose and dispose of the writ appeals. Yeah. The relevant findings, the relevant paragraph is reproduced here in the page 67. We have heard learning concept of parties from here, up to last page 68. Next one. On the next page, perusal of the above order passed by the division bench clearly indicates that, clearly shows that the division bench, the finding of the learned single judge with regard to the learned single judge has been upheld by holding that the learned finding recorded by the learned single judge that the appellant, having been regularized in the year 2005, did not have requisite length of service or eligibility for promotion to the grade 3, could not be shown to be factually erroneous. It also reflects that the case of the appellants is not that any relaxation was made in the eligibility requirement. And in the absence of relaxation of the said requirement, the rules had to be followed, and the appellants could not be appointed in violation thereof, as has been done. Accordingly, the direction was issued to the state respondent authorities either may initiate a fresh selection process or take a decision on regulation of in accordance with the rules. The next paragraph. Despite a clear direction of the division bench of this court, it is noticed that no action has been initiated either for fresh selection process or
Lordship, only thing is, Lordship, it is in respect of appealants.
Any decision has been taken for regulation of the incumbents. It only, however, no, it is also seen that the respondent authorities by various communications have expressed the difficulty in reverting back the petitioners and other similarly situated persons, including appellants in those writ appellants, to revert back to the original post of grade 4. Consequently, in consequence, the petitioners and other similarly situated persons have been allowed to continue in the promoted post of junior
Junior
assistant
assistant,
till that.
till that.
Next paragraph. Having considered the orders of this court within bracket supra, no doubt the appointment of the petitioner was not in the
Promotion.
appointment of the promotion of the petitioner to the post of junior assistant was not in accordance with the rule. However, despite a clear direction from this court, no action has been initiated for either for selection, express selection process or decision on the regulation of the petitioner in the post of junior assistant, rather allowed the petitioner to continue till that in the said post. It would be difficult to take a view that the petitioner may not be eligible for consideration to the higher post. Although legally although technically the petitioner has not been regularized
In
the post of
junior assistant.
junior assistant. Technically, Mr. Next. Considering that the respondent authorities has expressed difficulty, have expressed technical difficulties in reverting back the petitioner and other similarly situated person to the post of grade 4, having the post being abolished by then, and allowed the petitioner and other similarly situated persons to continue in the post of junior assistant after they were promoted, even promoted. I'm of the considered view that interested justice would serve if the respondents are directed to consider the case of the petitioner, to first consider in the case of the petitioner and take a decision on the regulation of the service of the petitioner, taking into the facts and circumstances of the present case. Listen. In view of the above. No. Accordingly. About the considered view. No, according the petitioner. The respondent authorities are directed to directed to consider the case of the petitioner and take a decision first on the regulation of the service of the petitioner, and thereafter consider her case for promotion to the next higher post in accordance with the law. The writ petition stands disposal in terms of the law. I'll give you to allow you to file a representation so that you can bring the things more clear.
Yes, only one humble prayer, my lord. She is going to retire, so it should be a time frame. Otherwise, 1 year they will.
Within a period of 6 months from
Lord,
today.
Lord.
6 months.
3 months, my lord. She said, "Repair this."
5 months. The, want to file a representation.
My lord, yes, within 2 weeks,
Will it be required?
not required, my lord. They can take, because my
It's okay.
regulation is not interfered with.
Yes.
Apply.
Lordship, I have a small prayer in this matter. We need some time to reconstruct the file.
See,
Please,
don't make a small prayer. Make a big prayer. You in life, if you ask something, ask for everything, not small. Yes,
This is for regularization, Lordship.
dismissed.
No, Lordship.
Why? Why
Lordship,
should
we have,
you are
we are the petitioner, Lordship, presently working as a tax collector, peon and proprietor
so?
under the Dorong district, Lordship,
Yes.
Panchayat department, Lordship. So, Lordship, we have filed an additional affidavit highlighting the certain fact order to ascertain to this honorable court, Lordship. Wherein, Lordship, highlighting that, Lordship, some of the petitioner has been appointed prior 1/4/1993.
I am similarly situated.
Of course, your Lordship.
How?
Your Lordship, presently, Lordship. there
Are you
three-
challenging their promotion? I mean regularization.
Lordship, there is a full bench judgment, Lordship, Jitendra Kumar Nath, Kolita versus the state of Assam, Lordship. There is a regularization scheme has been made out by the state cabinet decision, Lordship. That is 24/2019/95, Lordship. On basis of that, Lordship, we are entitled to get regularization, but inadvertently, Lordship, our name has been left out from such regularization scheme, Lordship. Regularization has already been.
It's still in force.
Your
It's still in force. The scheme is still in force.
Yes, Lordship. Lordship, the coordinate bench has already been passed an order, Lordship, wherein directed the respondent authority to regularize the similar situated person service, your Lordship.
You first establish your case, then come to the law.
Your Lordship, there is a this is order, Lordship. Passed
Sir,
by the
tell us,
coordinate bench.
you submit on the facts of the matter and then the case and place the law.
Your Lord, law is a very certain that, your Lordship, the state cabinet has took decision, Lordship, for regulation of the services of the,
Petitioners.
not the petitioners, Lordship, the
Then,
similar situated person, Lordship,
What
like the
is the
casual
po-
employee worker, Lordship.
huh?
But, Lordship, in the year of 2017, Lordship, government has, Lordship, in pursuance of the government has,
First, clear
Yes, sir.
about the schemes. Decision of the cabinet. Where is that?
yes, Lordship, this is the decision of this cabinet, Lordship.
Why not on the loose seats? I'm saying first you are talking about the cabinet decision. Where it is? Have you annexed it?
Not annexed there, Lordship.
Are you comfortable arguing the matter?
Yes,
Are
now,
you prepared?
yes.
Then argue start from beginning.
In this case, Lordship, although we have filed the present joint writ petition, Lordship, but out of such writ petition, only the number of the petitioner entitled to get regularization as because they were appointed prior 1/4/1993, as because there is a government notification, government regularization scheme which was made on 24/2000 to 1995, Lordship. So, Lordship, in original bench,
2095.
a full bench judgment, Lordship.
2095.
No, 1995.
Yes.
1990.
Then
So, Lordship, there is a full bench judgment, Jitendra Kumar Kalita versus State of Assam, Lordship. There is a regularized the certain employees, Lordship, who have been.
what about the Upendas?
No, Upen Das is not a seal for regulation of the workers, Lordship. Upen Das may be,
No, I'm
Lordship.
saying what?
After Upen Das, Lordship, the honorable FS court, Lordship, passed the present present judgment lordship, there is a 2025 judgment lordship, Honorable Supreme Court lordship, very much clear that lordship, that
Why
a
am I jumping?
casual worker has
I'm
also
just,
entitled
I'm
to
just
this regularization.
interacting with you. What is the situation when you are referring to? Why are you jumping onto the decision of the court? First, you establish your case, then refer
Your
to that
lordship,
judgment.
on basis of the Upendas, presently we have been receiving the minimum scale of pay.
So,
Although we have receiving minimum
so what
scale
is
of
the
pay,
right to be regularized? What is the right of your regularization?
right of the regulation, as because lordship, there are three criteria lordship which has been prescribed in the Honorable Supreme Court. Your lordship know very well that the Uma Devi judgment Karnataka lordship in para number 44 lordship. There is a three criteria can be prescribed to be regularized. Number one is that person concerned can be continued more than 10 years lordship. In this case lordship, we can continue our services more than 10 years. And another second point is that lordship, working in a duly sanctioned vacant post. So lordship, we have been working in a duly sanctioned vacant post. And third one is your lordship, duly qualification. We have a such qualification. Your lordship, the present Panchayat Act has been enacted in the year of 1994 lordship. But lordship, our case is prior enactment of this act lordship. So 141 is not attacking here. Lordship.
141?
No, not attacked in this act, your lordship. So
Who is saying it attracts?
prior 1994.
Who is saying it attracts?
So,
You yourself saying that it's not doesn't attract. How do we know?
Section 140 lordship.
We don't know what is 140.
140 lordship, that is a staff selection board lordship. Although we are not appointed lordship by the due procedure of law lordship. So as per the 140 of staff selection board lordship, as per the Panchayat Act lordship. So lordship, our appointment has been made out prior to this lordship.
Is there any provision for regularization?
Yes, there is a for regularization, your lord. Jila Parishad, Anchalik Panchayat, Gaon Panchayat, grade 3 and the grade 4 tasks shall be appointed by the Chief Executive Officer Jila Parishad on the recommendation of the District Selection Committee of the Panchayat and Rural Development Department constituted by the government in the Panchayat and Rural Development Department. Grade 1 and grade 2 officers shall be posted in the Panchayat and Jila Parishad by the state government. Provided appointment under subsection shall be made by the Chief Executive Officer without the prior approval of the state government. That is case relating to the appointment law. But our appointment has been made out prior enactment of this act law. So lordship, the under Constitution 173 amendment lordship. So Panchayat has inclusion and given the status of the constitutional right lordship. So the constitution should have been functioned properly lordship.
Are you lecturing on constitution today?
No, lordship, just I am draw attention lordship that we are holding the post of presently under the Gaon Panchayat lordship. So for smooth functioning of the Gaon Panchayat lordship, our post must be regularized lordship.
Do you have any doubt? Do you have any doubt that I may not have any knowledge on Panchayat?
No, sorry, your lordship is the superior authority and lordship.
No, I'm not superior.
I'm not going to draw attention.
No, that's why it appears that you are trying to schooling
only because of that I am saying that without the presence of our status lordship in local Gaon Panchayat lordship, Panchayat cannot constitute a running function with properly.
What is your right? How you can be regularized? On what basis? What is the basis of your claim for regularization? Tell us that.
On basis of that,
why we are going for its constitutional amendment?
We will our services in a duly vacant post more than 10 years. Other hand lordship, three criteria prescribed by the Honorable Appeals Court, even the various judgment of the Honorable Guwahati High Court lordship. There is a clearly indicated that three criteria must be necessary lordship.
When you are not, appointment is not in accordance with rule.
Our appointment is not made out in the as a constitutional maintaining the constitutional provision. Our appointment is not illegal appointment. It may be irregular lordship. I admit it. We admit it. Our appointment is may be irregular, but not illegal. Although illegal lordship, we
explain irregular and illegal. Explain irregular and illegal appointment.
Illegal appointment, illegal means illegal lordship. That irregular may be lordship. It may be irregular in the provision of the constitutional scheme lordship. May be irregular. In case of appointment lordship, the constitutional provision has not mandate lordship.
Then
That is
what
the
is
irregular.
what is illegal appointment?
Illegal appointment may be obtained such making fraud and forgery lordship.
Huh?
Making by a fraud, that is it may be illegal.
Making my
Making fraud lordship.
what do you mean making false?
So illegal means the illegal, your lordship. Maybe such provision has not maintained, due procedure has not followed in by the authority itself or by the petitioner, lordship, but
Yes.
appointment has been done.
Lordship,
It's beyond my ken. Yes.
Lordship, initially I sought for some time. We need to reconstruct the file.
Huh?
We need to reconstruct the file. We have
Are yaar. Why you are saying now? You don't have to brief now.
no, Lordship. We have to reconstruct it.
Your lordship, in this case, lordship, they have not yet filed
Yes.
additional
Kindly-
affidavit. May be
kindly-
required.
You make your argument on next date
Your lordship.
chronologically.
Yes.
First, you will make your submission on facts
Your,
and then come to the law. The basis of your claim, kindly make it systematically.
your lordship.
Just arguing the constitutional amendment, Panchayati Raj system and all the, it will not help you. And just dropping whatever documents you want to rely, you file it. Who is stopping that? Loose
Lord.
submitting, we tend to forget and it's tend
I
to be.
will try to find out the cabinet decision.
Forget about cabinet decision. You may have. You don't have that now.
Lordship, I
You
have,
find it
but
out that.
not
All right.
certainly the specific.
And
cabinet
then not
decision.
only that Jitendra on and all, you read Open Das also, read properly the Uma Devi. Thereafter,
Yes,
recently,
yes,
after ML Kesri also explained Uma Devi. And 2025 recently, it has
Yes.
been further explained.
yes, yes.
These are the laws, if you want to place, you place it. That's why I ask you, are you comfortable in arguing? So kindly assist the court to render proper justice, not
Your
this way, that way. And Mr. So-and-so learned counsel for the petitioner.
AK Khush.
So-and-so learning counsel is allowed 3 weeks time to file affidavit, including reconstruction of his brief as stated, as prayed for. You may also file any affidavit. Bring your records which you are relying, except the law.
Your-
All right?
Obliged.
Khandala,
My lord,
Atikya Khandala.
my lord, here my lord, petitioner was appointed initially as additional teacher, thereafter he was additional assistant teacher initially in 2007. Thereafter he was upgraded as assistant teacher. Our case is that, my lord, I am the social science teacher and respondent number 6 and 7, they are both are language teacher. But the district scrutiny committee recommended the name of respondent number 6 as social science teacher in our place. So, my lord, firstly, I'd like to take my lord to the page 44. This is the district dice code, district information system. Page 44, relevant page 43. SSA.
Affidavit where?
Oh, respondent number 3.
Last question time taken.
Page 43, my lord.
Filing.
Josna Wala Roy.
Lordship, on the last occasion, Lordship, the SSA has thought time to file their affidavit. With the matter pertains to the dice code, but clarification need to be submitted by the SSA.
No, I have annexed the dice code, my lord. This is page 43 is the dice code.
Respondent number 3 taken time now, last of the
Respondent number
3.
3, na?
Hmm.
My lord, perhaps last occasion respondent number 3 took time for filing everything.
Huh?
Perhaps last occasion, my lord, respondent number 3.
Taken the time for filing an affidavit.
So,
So,
as
no, I'm not for, actually, I'm for the 6 and 7.
who is for 3? So, are you not filing? No, who has to file? 3, who is 3?
3 is the chairman of district scrutiny, deputy commissioner. My lord,
Deputy Commissioner. So he's the one who has taken a time.
Yes, not seven or last.
taken a time.
Last occasion.
3, respond number 3. Yes, why you are not filing it?
My lord, respondent number 2, director has already filed. So we can proceed on.
What proceed? Your,
Since my friend is.
see, what is your case? Your case is that
My case
these
is that
respond number 6 and 7.
6 and 7 both are language teacher. So there cannot be 2 language teacher for provincial.
But then they have been provincialized as social science and the Hindi
So,
language.
But.
They are senior to you.
Senior to
What is
me.
the requirements? 5.
Requirement, my lord,
5
subject-
teachers.
Subject wise, my lord.
5 teachers.
3 teachers. 1 teacher for science and mathematics, 1 for language, 1 for social science.
Okay. So
Yeah.
6 and 7 have been provincialized.
Provincialized, but 6 is not our case is that 6 is not the social science teacher.
How do we know?
Page 43, my lord. Page 43, this is the district information system of the.
Okay, we're not.
Page 43, my lord. Top, my lord, Josna Bala Roy. He is respondent number 6. My
Just
lord,
to
what-
again verify all this information. The state level school recommended in name of the respondent 6 and 7 as social science teacher and the teacher respectively. And you are agreed by whom?
I am
6 or
agreed-
7?
6.
So why the 7 has to be a party?
Because 7 also language, 2 are language teachers.
Huh?
Because 7 also.
7 is Hindi.
Hindi means.
So you are not concerned.
Now I am not.
You are,
Basically agree, Kevin's respondent number 6.
you,
I am social science teacher.
he could also be equally social science. Who is senior to you? Between you and,
But Act provides
between you and
respondent number. I am junior,
them,
but Act says there is no seniority junior.
doesn't make.
No, my lord, it's very specific.
What is to be done when there are two subject teachers
My
in
lord.
social science?
My lord.
What is the criteria of picking up selection?
My case is that respondent number 6 is not social science. He is
They are
language.
saying that there is social science.
I am social. I am social.
You may be, he or she is also.
No, she
equally-
is not. That is page 43 clear.
Let us see.
Page 43 is the dice data, my lord, of the school. It says that respondent number 3 taught language, that is page 43, my lord. Josna Bala Roy, she is respondent number 6.
What is it?
Down below, my lord, main subject taught,
Where it is?
page 43, my lord.
43, yes?
Top, my lord, Josna Bala Roy, name. She is the respondent number 6.
Type
Now,
of
my lord,
teacher.
serial number 14, down below, main subject taught, 2, language.
14.
14, page 43, number 14,
Main subject
taught language.
2 languages.
Then, my lord, come to below down, middle, Abdul Sobur Rahman. He is the petitioner.
Where it is?
Same page, my lord, 43. Just down below, middle, my lord. Abdul Sobur Rahman.
Abdur, ha.
He is the petitioner, serial number 14,
Main subject, social studies.
social studies. So I am social studies. Then, my lord, page 44. In middle, my lord, Abdul Rezzaq. He is respondent number 7. Just
English, you are also.
He is English.
Now English.
English, he is English.
English is not required.
So, Josnawala also language. Abdul Rezzaq.
See, Josna uses serial number. Appointed for subject, all subject.
But
Yes,
main
yes.
subject.
You
what?
are also
subjects.
appointed on all subjects.
Yes.
right?
But subject taught, mainly taught, my lord, that is the case.
No, then Abdul Razak. Subject upon all subject. Now main subject taught. Now this is your English now. No, you are no social science.
My lord, I am social science. They are not social science. They are language. So there cannot
So
be.
page 44 is what?
Page 44, Abdul Razak, he's English also language, my lord. It's also
So he's what? He's respondent number 7.
he is respondent number
So
7.
you are not concerned about this.
We are not concerned. He may be provincialized. But there is respondent number 6, my lord.
Yes, show us. Who has to show?
Lordship, I have already filed my affidavit, Lordship.
Yes.
Lordship, kindly take up the affidavit filed by the Director of Elementary Education. Lordship.
Yes. Respondent number?
Lordship may kindly come to page number 107. This is a part of that scrutiny, district scrutiny committee resolution.
Respondent number?
Here, Lordship, kindly
Page.
page number 107,
107.
clause 6. Your Lordship will find.
If they didn't reply. Sorry, 107 is something different.
107 is the relevant.
Yes.
Your Lordship will see.
Format for report of district scrutiny committee.
Lordship,
Yes.
clause 6.
Yes.
Details of tutor eligible for provincialization. Ashraf Ali Sheikh, Science and Maths. Josna Bala Roy, subject taught, Lordship will find. Column 3. Subject taught, social
Abdul
science.
Razak, Hindi.
Abdul Razak, Hindi.
Ah.
Therefore, social science is taught by the respondent.
This is from a format for report of district scrutiny.
District scrutiny committee.
That is what he challenged.
I am challenging this.
On the basis
He has
of this,
said illegality. Here,
and we have clarified in our affidavit, Lordship, will come to the page number 102. Rather 103, Lordship, paragraph 5. That the district elementary education officer Dhubri submitted proposal for provincialization of services as per Act 2017 with the recommendation of the district scrutiny committee Dhubri, in which the following 3 teachers were recommended against so and so school: Ashraf Ali Sheikh, Maths and Science; Josna Bala Roy, Social Science; and Abdul Razak, Hindi. The name of the petitioner, Abdul Sabur Rahman, was not recommended by the district scrutiny committee for provincialization of service. His name was not recommended by the district scrutiny committee. Therefore, based on the recommendation of the district scrutiny committee, the state selection committee approved the name of these 3. And Lordship may kindly come to page number 104, first para. It may be stated herein that, as per report of the DO Dhubri, the petitioner was appointed as additional teacher by the school managing committee of the school in 2007, whereas this respondent, private respondent, was appointed in 1991. 1991. Thereafter was upgraded to the post of assistant teacher in 2014. The respondent number 6, Josna Bala Roy, was appointed by the school managing committee in 1991 and she taught the subject social science. Therefore, the respondent number 6 taught social science, Lordship. It may further stated herein that, as per data report furnished by the SSA Assam, the enrollment position of the school during the year 2016-17 and 17-18 was 85 and 104 respectively. So therefore, based on the enrollment position of the school, Lordship, they are eligible. This school is eligible for provincialization of 3 teachers: science and maths, social studies, and social science and language. So these 3 teachers are senior than the petitioners. Therefore, their number has been recommended by the.
There is no dispute.
There is no
dispute. Is
Lordship.
By referring to page 43.
Lordship.
In DISE.
Lordship.
Right.
Lordship.
The petitioner is shown to have been appointed for social science subject.
Lordship.
Right.
Lordship.
And the respondent number 6 is for language.
Respondent number 6 is Josna Bala.
Top. Right
Lordship.
side, right hand side.
Lordship.
Top.
Here, Lordship, if your Lordship sees the serial number 13, here also it is shown all subject. And against the petitioner also, it has been shown all subject. But the
It
report
said
of
main.
Main, I am on main subject.
main subject.
Page 43.
Main subject of social studies. But the district scrutiny committee, in that case, Lordship,
Appointed for subject, all subject, main subject taught language.
appointed all subject, Lordship. So because
This
this
is
is a,
for all, my lord. All teachers are.
No, it's okay. What is the requirement of the provision? What does it say?
Provision, my lord, the act says, my lord, when a student is below 100, then there must be 3 teachers. 1 teacher for language subject.
Who taught? Is a teaching is a requirement?
Teaching is because subject, provincialized under this act, 17 act, on the basis of.
So when the persons were appointed on all subject, you also.
I also,
Also.
she also,
Also.
but main subject.
That's why main subject is it the requirement. Read the provision.
My lord,
Read the provision. If the requirement is that a person to be provincialized must have a teaching in a particular language or a subject should be appointed, then you may be
But
correct. If not,
that is, my lord, but our case is, my lord.
your case is that she taught a language which could not have been appointed as a subject, social science. That's your case. What is the requirement?
Requirement, my lord, under page 111.
6 and 7.
Oh.
6 is the most of the senior person.
it will quite easy.
Page 111, my lord.
Read it.
In case of
3 words. What is that section?
section 3(1)(11),
Read.
in case of Bensar Upper Primary School, there shall be minimum 3 teachers or tutors. At least 1 teacher is for social science and mathematics, and then, my lord, social studies, then languages. So, my lord, 1 teacher.
What does it say that a person to be provincialized, a teacher to be provincialized must have taught a particular subject?
My lord, that is
Because appointment is your own saying is all subject, yours is also
Yes,
all
all
subject. If you are for all subject,
But my case
and the
is that
requirement is, there is no requirement of teaching expressed in a particular this thing. When your appointment.
there is, even, my lord, there is no, because there is no post for all subject. Who is teaching all subject, he is not entitled to provincialize.
Where is the law? Where is
Law,
the requirement?
my lord, this section, my lord, in case of, I am reading, my lord, in case of upper primary school, there shall be minimum 3 teachers.
Yes.
Or tutors.
Yes.
At least 1 teacher is for science and mathematics, 1 for social studies, 1 for language. So, my lord, who is teaching all subject, he will get not chance, any chance. All subject has no chance in this act for getting provincialization. Who is teaching all subject?
And
The
more
question, when your appointment is for all subject.
No,
and the petitioner being the junior most amongst all.
Then.
No, my lord,
I've understood your case. I'll decide. All right. Your case is you, although you are appointed for all subject, you taught particular subject, that is social science.
Social science.
And the respondent number 6 appointed, though appointed on all subjects, but she taught language. Therefore, she could not have been appointed as in the social science subject. That's all.
That's all. But my appointment letter I have annexed, my lord. Here is not for all subject, my lord. I am for just.
This is what you are relying, page 43.
Page 43, that is the.
Since you are relying it, but the question of.
Another aspect
And
is
the district scrutiny committee report clarifies that.
And then who is for respondent number 6?
Yes.
Yes, show us. What is your appointment?
Appointment is, she is the senior most of this teacher.
Forget about this.
1991.
Dispute is which subject you taught.
Initially, she taught this social science teachers. And after provincial,
Show us any
Show
document.
us any document, my lord. My case is that.
Show him, he's asking.
Show me, my lord. If anything is there, she is choosing, she is teaching social science.
What is your appointment?
appointment is,
My lord, page 27.
Hmm.
I have filed an affidavit, Lordship.
28 is the vernacular, my lord.
20 is not vernacular. This is original.
Oh, original.
Xerox copy of the original. This is type copy. What do you mean by vernacular?
My lord, sorry, my lord.
Appointment assistant additional teacher in Banayamari ME School. Huh?
My lord.
So,
Lordship,
additional teacher, there is no subject mentioned.
No, in appointment letter, there is no mention of subjects, my lord.
Then,
In all,
then why you are showing this?
this
Who
is the dice information.
Who is disputing this? You were appointed in 2007.
yes,
My lord.
Respondent 1991.
yes.
There is no dispute
That may be, my
on
lord.
the seniority.
But, my lord, on the
You
basis.
show us that your appointment was for social science subject.
My lord, in appointment.
Because your appointment for all subject, you taught social science. She also appointed on all subject. She taught language. Who is the bar?
No, because.
That's why I'm asking, why is the provision that the one should have for provincialization of a teacher, must have a experience or she must taught the subject, particular subject.
My lord, since there is only 3 posts can be provincialized under the act. One for language, science and mathematics, and one for social science.
Yes.
So, my case is the respondent number.
Your case I've understood. That's why I'm asking. If on the basis your submission on your pleading,
No,
I'm asking.
on record I have shown. Now, my friend, kindly.
See, record says that your appointment is for as an additional teacher, right, in 2007. And DIC codes shows that you taught social science,
Social science.
but appointed for all subject.
My lord,
That's why I'm asking, you taught social science. Show me the provision in the act that one should have an experience of teaching in particular subject for provincialization,
it
his
is
or
not
her
in the
service.
act, my lord. It is not under
If
the
it's
act.
not that,
Even under the act, one provision, another provision is there, my lord. That is section 14. 14, if because I am agreed by the recommendation of district scrutiny committee. District scrutiny committee illegally dropped my name and recommended the name of respondent number 6 as social science teacher. There is a appeal provision, my lord.
so
My lord, I have also filed appeal under the provision. Appeal is also not been decided. So let them decide my appeal. Because under the
where is the prayer for?
I have, my lord, I have page 55. Sorry, my lord, page 50 of my writ petition, page 61.
It's 2021. When did you
My
file
lord.
that appeal?
Or 16, 12, 21.
Huh?
16, 12, 21. Till date, it is not decided.
No, Lordship, what happened is, there is a provision under section 14. If he is agreed by the order of the district scrutiny committee, he has to prefer an appeal before the state level committee,
Yes.
not to the government. And he has
Well,
preferred this appeal to the
No,
government.
my lord, I have preferred page 55 to the director. He is the chairman. Page 55.
Chairman,
55.
Deputy Commissioner.
No, my lord, page 55 to the director. 18, 10, 21.
Director of Balloons.
My
You
lord.
could have said so if you want.
No, director, he is the under the act.
I have heard you enough. I'll dismiss on, I'll decide on merit.
No, my lord, but my appeal, that may be reflected, because under the act, there is a provision, appeal provision.
If once I decide, what's the question of appeal?
My lord, I have right to file appeal under the act. If I am a.
Why you have not,
I filed.
then withdraw it. Withdraw it, will grant a liberty to approach.
Then I will file a fresh appeal, my lord, if my lordship can.
Will you withdraw it? Or I am deciding on merit?
My lord, let me, my appeal be decided. My lord,
Why you have not said so earlier?
otherwise, I may be allowed to.
Well, you are caught. You want to, your appeal should be dismissed.
No.
I have not, I'm yet to decide. I'm just interacting with you.
Otherwise, my lord, liberty may be given.
Otherwise, I'm dismissing it.
My lord, my submission is that, my lord, since there is a provision of appeal, let my appeal be decided, my lord. Because section 14, there is a.
Hard listener. Kandar, what is this? M.R. Khandarkar, learned counsel for the petitioner, and also heard Mr.
P.N. Sharma.
P.N. Sharma, learned standing counsel for
Elementary education.
Elementary Education Department.
Respondent number
Comma.
1, 2, 4.
For respondent number
1, 2, 4 and 5.
1, 2, 3.
Yes, Chakraborty, I am for 6 and 7.
6. Yeah. By filing this writ petition, the petitioner has put to challenge the provincialization of the respondent number 6 and 7, namely, you take that name, namely so and so, as tutors,
My lord,
of tutors, as teachers oblique tutors in the subject social science and language subjects, social science and language of Baniamari ME School. Which district?
in the district of Dhubri.
In the district of Dhubri, Assam. List of the petitioner has joined his service as additional teacher in the assistant teacher within bracket additional in the Baniamari ME School in the district of Dhubri on 02/01/2007 and claims to have been teaching social science subject till today.
No, now
You are no
school-
longer.
School is merged with another.
Okay.
Yes.
Till the said school was provincialized. List of. It is the contention of the petitioner that the district level scrutiny committee, what do you call DLC? District level committee
DHC, district level scrutiny committee.
has recommended the name of the respondent number 6 and 7, namely so and so, so and so. You get it. For provincialization of their services, although the despite the fact that the respondent number 6 has taught only the language subject in the school, ignoring the fact that the petitioner had been teaching the social science subject. Mr. Referring to the, please, therefore, the provincialization of the petitioner, respondent 6 and 7 is not in accordance with the provisions of the, what do you call?
The Assam Venture.
The Assam Venture, where it is, where do you get it?
That is, my lord, page 111.
Assam,
My lord, I'm saying.
that's a,
The
Assam
Assam
provincialization,
education.
so, you just give that 2017. Next pair. Mr. Kandahar, Learned Council for the Emar Khanda, Learned Council for the petitioner submits a comma while referring to the DISC. What is that?
District Information System for Education.
Referring to the page 43, 43, right?
43, 43 and 44.
Referring to the entry status of district information, what?
District Information System for
System
Education.
for education.
Within
Within
bracket
the
DIS.
DISC, commas. Submits that the DISC clearly shows that the respondent number 6 and 7 were teaching the main subject, were teaching the language as main subject. Whereas the petitioner was teaching the social science subject, teaching the social science, social studies as main subject. List. Therefore, the provincialization of the respondent 6 and 7. No, provincialization of the service of the respondent number 6. The particular respondent number 6 is is not in accordance with the requirement as provided under section 3.
3.1.
3.1.
11, Roman 11.
Within bracket, Roman 11, bracket plus of so and so, so and so.
Of 17.
2017. Mr. Next paragraph. As such, he praised that the provincialization of the respondent number 6 may be set aside in first. Next paragraph. Mr. P.N. Sharma, Learned Standing Council. Which page number? Your
107, Lordship. Details of teacher eligible for provincialization.
Respondent number 2, Director.
Lordship, respondent number 2.
Which para you are referring?
Lordship, I am referring para number, Lordship. 5. 5. And Lordship, that District Scrutiny Committee minutes, page number 107, where it has been stated that Josna Bala
Referring to
Roy,
the
subject
affidavit
dot
of which
social
is filed on behalf
social
of
science.
number 2, page 103, para 5. For these years, you don't submit it, then submits the proposal for provincialization, so and so, so and so. You just para 5. Para 5, not the annexes and all. Right? What is this? 107.
107, Lordship.
Yes.
Clause 6.
Hmm.
Subject dot, column number 3.
Hmm.
Ashraf Ali Sheikh, Maths and Science, Josna Bala Roy, Social Studies, Social Science, and Abdul Raza, Hindi.
Mr. Sharma, non-standing counsel, for the, referring to the format for report of district scrutiny committee,
These are minute of the
Well-
district scrutiny committee laws.
where it is clearly shown that one Ashraf Ali Sheikh has been appointed as mathematics teacher, comma, the respondent 6 and 7 have been recommended as not appointed, recommended as social science and Hindi teachers. Therefore, the and the petition, the respondent number 6 having been appointed in the year 1991 and petitioner being in the year 2007. The respondent number 6 is much senior to the petitioner. And the initial appointment of the respondent number 6 and number 6, 7 and petitioners were all in all subjects. However, they might have taught different subjects before the provincialization. The provincialization, therefore, is in accordance with the rule, according to section 3 of science. Am I saying so? Well, London Council for Response 6 and 7, while adopting the submission of London Council for the London Standing Council, Mr. Sharma submits that the provincialization is of the respondent 6 and 7 has been effected under after due process of selection, including the recommendation by the DLC in accordance with the so and so. Consider the submissions of Learning Council to the parties and the evidence of the so and so, including the provisions of so and so. Materials available on record and including the provisions of so and so Act 2007. Are you getting it?
My lord, my appeal, my lord.
On-
Please. My appeal is there also. Case 55, under section 14.
See, once I decide, there's no use.
That may be mentioned, my lord. I have filed. Because under the act.
After,
Worship, interim is.
interim is there.
Yeah, interim is there, so respondent has not been paid
Okay,
any
I will
salary.
vacate it and send it back.
Yes.
No, my lord,
After
my lord, one thing,
having,
my lord, may I submit
after
one-
arguing the, I'll record my findings.
findings,
But then
there
I'll
are
not,
maybe sent
clearly
back also
I'll
back
send back.
to decide if it's. Or
On perusal of the provisions, particularly section 3 of so and so, shows that
No, no.
the so and so, you put that section 3, So it's, therefore, the requirement, the provision provides that list of it. Does the provision clearly provides that in the provincialized school, upper primary school, 3 teachers, particularly for one for say mathematics,
No,
one is for
one for science and mathematics
science and mathematics,
and one for social
and
science.
one for social science, social
And one
studies,
for
language.
studies or social, you just said, it's better. And one, and for one for admin. A total of 3 teachers would be appointed, provincialized. The records reveals that the petitioners, the respondent number 6 and 7 were appointed in much earlier than the petitioner. They being appointed in the year 1991. What of them?
No, one is 1991 and another is 2003.
1991 and 2003 respectively. And the petitioner being appointed in the year 2007. The GISC, that called,
District information
is
system.
heavily relied on by the learned counsel for the petitioner. Also provides that they were all appointed in all subjects. Although they are shown to have been teaching a particular subject, namely languages and namely in language subject by the petitioner number, respondent number 6 and 7, and social science, social studies by petitioner number 1. The appointment orders of the petitioner clearly shows that he has been appointed, has been as an assistant teacher within the edition in the year 2007, without mentioning a particular subject.
He was
List of.
in 14 or
It is
something.
also revealed from the record that the respondents 6 and 7 have also been appointed as assistant teachers without mentioning a particular subject. Although they appears to have been teaching some particular subject like language. And rather shown to have been appointed for all subjects. Next paragraph. It is also to be noted that the requirements of section 3 is for the provincialization of 3 teachers for 3 teachers in 3 subjects, namely social science and mathematics. You just check it out. Science and mathematics, comma, social science, social studies. Well, social science or social
Social
studies?
science, social
Social
science.
science and language. And it does not provide for any experience in, it doesn't provide for a particular experience to be appointed in the above 3 subjects. Thus, the claim of the petitioner that he been teaching the social studies and the respondent 6 being teaching the language subject, he ought to have been considered for provincialization in place of the respondent 16. Cannot be accepted. Next paragraph. After having been considered and they consider the submissions of learned counsel for the parties, and also after completing his argument. No, however, next paragraph, Mr. Spencer, after completion of his argument, by taking a considerable time and having been considered by this court, he fervently urged that instead of deciding the issue on merit may be directed the respondent authorities to dispose of his representation
number two.
appeal filed under section 14 of the so-and-so Act. Page, where is it? Page
Page 55.
55.
Respondent number 2, before the respondent number 2. Direct.
Next paragraph. Although the respondents, and counsel for the respondents have objected, they vehemently objected to such prayer. Having considered that the act of so and so provides for an appeal before the appropriate authority, before the appropriate appellate authority under section 14, creating a statutory right of appeal, the prayer of the petitioner, along counsel of the petitioner, for a direction to dispose of the appeal filed by the petitioner is reluctantly accepted. Mr. In the next one, having considered the petitioner, the respondent authorities, particularly the Director of Elementary Education, Government Masan, is directed to dispose of the appeal filed by the appeal dated 18/10/2021, filed by the petitioner within a period of 4 months from today. It is made in the
Lordship, I have also,
very difficult.
Lordship,
I may, once I decide, I decide, I cannot say that again not to pass
yes,
appropriate orders.
Lordship, I have also,
I'll decide finally. Interim order passed, the writ petition instance closed and disposed of. Interim order passed, alias cell. Cell stands vacated.
So, my lord is not remanding well. So disposal of it. Lord, my submission regarding appeal may be recorded.
I have recorded already and I'll think over it. What to do. Because my finding is already dismissing the writ petition. Then I am remanding that will be, I mean, but I'll see. Despite my finding, I'll direct them to dispose of appeal. That
But
balance,
there
I
is-
just say.
Since there is a statutory provision, that is why.
Please, your lordship.
Yes.
Lordship, today we have received a copy of the affidavit.
Lordship, we have filed an affidavit today. They have received it today.
Lordship, the finance department is yet to file their affidavit, lordship.
Which
There is
finance?
number 2, lordship, hear it.
They were
Articles
here.
1 and 3 have filed their affidavit,
You have to file reply.
lordship.
Ms. So-and-so, counsel for the petition, Mr. C have received the affidavit in opposition to the
Filed by the respondent number 1 and 3, man.
accusation of opposition filed on behalf of respondent number 1 and 3.
One.
Mm. Today, huh? Get for praise that she may be granted 2 weeks time to file reply.
Lordship,
Yes,
I pray for a
yes,
date,
sir.
lordship. It's a 2022 matter.
Lord, can it be after 3 weeks, my lord? 3 weeks.
2 weeks.
2 weeks.
And the respondent number
3, lordship.
in the meantime, respondent number
No, it's one number 2.
2
Finance.
may also
Finance will file there.
their affidavit.
May I pray for a date, lordship? Much obliged.
We'll
DPO.
see.
The matter may be taken up on Thursday, Lordship. My senior is stuck in lower court for a hearing matter, Lordship.
Lower court.
Lordship may dispose of the matter because the petitioner is a employer-based society, my lord. And this honorable court in some other cases has already closed this type of matter.
Problem is, her senior is in the lower court. What to do? What is to be done?
This woman with the- Well, Thursday na hoga, huh? Like that. Friday. Friday ki date Saturday. Huh? Friday. Six. Bata diyan kaya nga.
Yes,
So it may be taken upon
it's a
us.
society
Yes, my lord.
registered under the Cooperative Society Act.
But this writ petition is not maintainable, they may approach the appropriate forum, my lords. They observed by this honorable court in that I have relied upon.
This is which society?
This society বহুমুখী Odalajar বহুমুখী মহিলা সমবায়.
Andolajar Bhomuk
Yes.
Mahila Sammasya. But the challenge is the order of the registered cooperative society.
Yes, hearing was conducted, but there, if there is any grievance, my lord.
We'll see. That are significant.
My lord.
On the prayer of Ms.
On behalf of RDB.
petitioner, Learned Council appearing on behalf of Mr.
That's
RDB, Mrs. RDB, Learned Council, who is stated to be engaged in trial court. Press for adjournment of the matter. Huh? Praise the Lord. This after 3 weeks.
Lord, sir.
MD Bora, that
The
is
Corporation Department.
Training Council, Corporation Department is present.
Lord, sir. Obligement.
Much obliged.
May I please, Your Worship? My lord, this matter relates to non-provincialization of lower primary school, my lord, on the ground that the petitioner is.
Affidavit is filed.
My lord,
Affidavit is filed.
no affidavit filed. In fact, last occasion, my lord,
SSA was supposed to file.
Where is SSA?
Yes,
Chaudhary, inform him. Further 3 weeks. Heard Mr. Swenso.
I'm saying, my lord, similar matter.
Further 3 weeks.
My lord.
The prayer of Mr. B. Chaudhary, Learned Council, Standing Council by SSA. List after 3 weeks.
My lord, similar matter fixed on 24th.
Let him file first. If the similar order is passed, that will guide.
Similar
That will
matter.
apply, that will be applied. All right, 3 weeks. Non-appears for the petition on call, list after 4 weeks. Non-appears after 5 weeks.
May I please, Your Lordship?
Yes.
My Lordship.
Item
Number 16.
after 3 weeks,
The 3 weeks.
5 weeks. What do you want today? Item 16.
16.
Yes, what do you want?
Lordship, Alright.
Yes,
My lord, I have filed a reply, my lord.
yeah, reply is there.
It is higher, standing council higher education.
What is the matter?
Matter, my lord, the petitioner
he was selected for the post of assistant professor in Bodo language in Dokona Kamyakumar Das College. But there was the age bar. So there was another notification of the Government of Assam in 1951 by which some age relaxation was maybe granted. So on the basis of that, we have filed in earlier occasion one petition for my relaxation of age. The Lordship being pleased with my grounds, given a direction to the department concerned to let me appear in the interview, and by this time they can also take the decision regarding my relaxation. And I was selected. I recommended. On the basis of that recommendation and in person of the Honorable Court Order, initially my age was, average age was relaxed, and I was, granted, approval grant for my appointment. Accordingly, I joined. After joining the service, the director again, realizing that he is not the authority to condone the age, so appointment order was cancelled. So so-cause was issued, and I replied the so-cause reply also that after following all the procedures, ultimately I was terminated from service. So against that, I have filed the petition. During that period, what happened? Another two similarly situated candidates. All Assam entered Assam. The total 10 Bodo posts were later on sanctioned in the college wise, and the other two posts in different two colleges, they are also in a similar footing. They are also in average. They were considered and appointed, but my case was not considered. So in that occasion, earlier occasion, Lordship he has asked the department concerned to come with all details. They say that there is no such provision for condonation. So that was the wrong interpretation of the directors, where there is a provision. That is why they have again another condoning two persons, they have been appointed. I have mentioned there. So on that issue, I have filed this, they have filed the affidavit, and I also filed reply.
Lordship, can this matter be taken up on 10th, Lordship? I need some time to reconstruct the file, Lordship. I have misplaced the file, Lordship. On 10th, Lordship, it's a hearing.
Mr. P. Mahanta, learn counsel for the Mr.
Diupamen.
Learn counsel, illustrating counsel, higher education.
Yes, Lordship.
Higher education department submits that
Pleadings are complete.
he has misplaced his brief. Therefore, press for a week's time to reconstruct his brief.
That may be fixed on 12, not on 10.
12
of June.
Just after a week.
12 of June.
Since they, it is also noticed that the pleadings are complete.
I'm for 3 and 4, Lordship.
Yes, sir. Yes, sir.
My lord, matter is relating to the appointment of the petitioner. So if that is not given, that is not listed, my lord.
It will be listed.
On
After a week, it will be listed. See, check
My
it.
lord, again, I have to mention, otherwise not complete.
Make a mention.
So, my lord, I'm sorry, my lord. Item 15. My lord, I was just coming, my lord. I could not reach. That may be taken now. Item 15 is simple matter, my lord.
No, it's already.
Item 15, my lord, regarding my lord, area salary, my lord.
After 4 weeks. After 4 weeks, record his name. After
My
4 weeks.
name may be recorded, my lord.
Item 15, sorry.
15 on 5, my lord.
After 4 weeks.
Obliged.
Already passed it. 16, 17, 17, 18, yes.
May it be possible. This is in fact third round of litigation. Third round of litigation for the petitioners, my lord.
For what?
In 2001, my lord, there was some advertisement for filling up a post of LDA in the office of CDPO, my lord, Judia ICDS project. My lord, we were selected candidates, my lord. By ignoring our claim, my lord, the private respondents were appointed. My lord, I challenge that in a writ petition, my lord. That was allowed. My lord, the respondents were directed to make appointments, my lord. We were appointed. My lord, then the respondents, private respondents, but they approached this honorable court again in a review petition. But in the review petition, my lord, there was an interim order. In that interim order, my lord, that order of 29/5/2003, by which, my lord, the respondents were directed to make appointment, my appointment, my lord, that was put to challenge because in that order, my lord, subsequent to that order of 29/5/2003, my lord, the respondents issued appointment order on 28/8/2003. I joined on 1/9/2003. In the meantime, the private respondents were dislodged, my lord. They came before this honorable court. They filed review petition, my lord. In that review petition, an interim order was passed, where, my lord, that order 29/5/2003, my lord, directing for my appointment was stayed, along with that order, my lord, of 28/8/2003, by which, my lord, the appointment order was issued to me. In the meantime, my lord, I entered appearance. I filed another writ petition challenging the order, because subsequent to the order passed by this honorable court in the review petition on, my lord, 11/9/2003, my lord, the respondent issued another order. That is on 14/10/2003. So I challenged that order of 14/10/2003. So all these writ petitions, my lord, the second writ petition which I had filed and the review petition along with the writ petition filed with the review petitioner were stacked together. Ultimately, my lord, it was heard and the review petition was dismissed. Then, my lord, after the dismissal of review petition, my lord, the respondents again issued a fresh, my lord, appointment order on 31/3/2005. My lord, here my claim is, my lord, since I was appointed in terms of the order passed by the honorable court, while order dated, my lord, 29/5/2003, my lord, my services ought to have been considered from, my lord, from my date of joining, that is 1/9/2003. That is my case, my lord. The respondents, my lord, they have filed, because there are also one letter, my lord, since I was not allowed to join in my place of joining, my lord, I reported my joining before the district, my lord, program officer. District program officer had informed that to the director also. Now I'll take a lordship to one annexure, my lord. Your lordship will find annexure 7, my lord, page 37. That this is the letter written by the district program officer to the director, my lord.
You are claiming arrears in salary.
Yes, because my initial letter appointment
You
was
have not been appointed. You have not in between. There was an intervention of the
no, my lord. Yes, yes.
saying that the
Yes,
appointment
but
order, then
yes, my lord. But that order was conditional. Lordship may kindly come to that order, interim order, my lord. 11, page 32. Page 33. I'll just show one thing, my lord. Page 32, Lordship may kindly come for a moment, my lord. Your lordship may come. This is the order, interim order passed in the review petition, madam. That's so and so, madam. Lordship may kindly turn to the next page, and lordship may kindly come to the last page. Madam. In the meantime, here's lordship got, madam. In the meantime, and until further orders, the operation of the impleadment order dated 29/5/2003 shall remain suspended. Consequently, the order passed by the authority on 28/8, that is my appointment order, madam, in furtherance of the direction issued by this court in this aforesaid judgment, shall also remain suspended, my lord, if the same has not been implemented in the meantime. Whereas, my lord, I joined on 1/9. This order is of, my lord, 11/9. That is 10 days after my date of joining. So now that's why, my lord, the honorable court, while disposing the review petitions along with all the writ petitions, had observed, my lord. Lordship may kindly come to that now. I'll just take your lordship straightway to that annexure, my lord. Annexure is at annexure 8, page 39, my lord. The initial pages are recitations of the first title, my lord. The lordship may kindly come to this annexure, my lord. I will just take that relevant paragraph. The lordship may kindly come to page 50. This is the order passed in the review and along with other date petitions filed by me and filed by the review petitions. All the cases were clubbed together and this order was passed. Lordship may kindly come to the last part of paragraph 7, starting with notwithstanding. Notwithstanding the slight error, my lord, committed by the court on account of wrong pleadings, advanced by the director on the facts now ascertainable, no case of review is made out. Because in the review petition, he claimed that, my lord, he was placed as serial number 5. But when in the review petition, when the director filed his affidavit, the director pointed out, no, he was not placed at serial number 5. His position was down below. Because my position was 11. There are two writ petitioners here, my lord. One writ petitioner's position was 11 and another was of 18. So we are far above the private respondents. That's why the honorable court had directed for our appointment, my lord, by disclosing the private respondents. So, my lord, the wrong has been done by the respondents, my lord.
Why have you prayed for here?
My lord, I am here, I am praying that, my lord, my date of joining
What is
should
your
be
writ
counted from
petition? What is your writ petition?
Writ petition? Your lordship will find that order of the honorable court, or initial order of 29/5 at annexure 2, page
It's
24.
okay, it is not initial. After the review petition, there was a stay.
Yes,
Of course, maybe conditional, but then
Yes.
do we know that
yes,
the petitioner, the respondent would know whether your joining was accepted or whether you
Yes.
were allowed to work or
yes, everything is on record. Now, my lord, they have come up with an affidavit saying that though the DPO, district program officer, has stated that they had joined in his office, but in the attendance register, the record is not found that they were continuing in service. That's the only ground they have taken. Whereas, my lord, DPO's letter is very clear. Lordship may kindly come to the annexure. Lordship may kindly have a look at the DPO's letter, my lord. Annexure 7, page 37.
listed for hearing. It will require,
Blood record is to be blood necessary because the order passed in 2005. He has come after 20 years, blood saying that I joined once upon a time. I should get the blood area salary. Why he did not go for blood contempt?
when you were
2005.
the proceedings, you have filed a writ petition.
Pardon? Pardon?
Second writ petition you have
Yes,
filed.
yes.
When the review petition was filed,
Yes.
pending, these were all taken together.
Yes.
Have you not prayed for those regulation of those services?
Nothing.
Of that period, my lord. What I do.
Third, Mr. Adhikari, then counsel for the petitioner. Pleadings are complete. List for hearing after mid district petition. List for hearing after 4 weeks. Mr.
TC Sutia, blood.
Jesse.
TC Sutia.
Then counsel. Then state counsel to produce the report. Record.
Record.
For 2 weeks, my lord.
4 weeks.
Obliged, my lord. Same order will go, the next petition also.
What is same?
Same.
Same appointment.
Yes, same appointment. Common appointment was there.
Yeah. This should be listed alone. Common order only.
Common order.
Yes.
Obliged, my lord.
Yes.
Also, in this case, the respondent number 8 and 10 have filed their affidavit in opposition lawsuit. So kindly allow us 2 weeks time for file our
On the prayer of Mr. Swenson and counsel to the police for the 3 weeks time. No, 3 weeks time is granted to file affidavit in reply. Mr. P. Nayak, standing counsel. BTC is present. And
I'm for element.
so elements are present. Huh?
Obliged.
David Gillen.
May it please the lordship. Lordship, the respondents are supposed to file affidavit.
Yes.
And for the last 4 times, secondary education has taken time to
What
file.
is the matter?
Lordship, the matter pertains to illegal promotion of juniors to the post of senior assistant in the district of Sivsagar, not considering the case of the petitioners. Lordship may find the may find the seniority list 20. In page 34. Annexure number 6.
Lordship, we appear on behalf of the private respondents, maybe granted some more time to file the affidavit.
Why?
Some of them had some.
How you are, what is your prayer? What is
Lordship,
your prayer?
Our prayer is to consider us to the post of
Senior assistant.
senior assistant,
Promotion.
same as that of the juniors who have been promoted.
How they are junior?
Lordship, what may find it on page 34.
Same selection process.
Same lordship.
Same selection process.
Lordship.
Same appointment
Same
order.
appointment order. Lordship may
Your Lordship,
Yes.
petitioner room number 1. He's at serial number
Who is this?
Diju Gogoi.
Did you go? Huh?
He's at serial number 15. Then private respondent Dekagiri Borbora, Ujjal Sharma, private respondent number 4. He's at serial number 19. Then Lordship may find Dhrubajit Mohantor, private respondent number 5 at 33, serial number 33.
Yes.
And
Then
Lordship, the petitioner number 4, which is at serial number 2, he is senior to all of the other private respondents. But some of the
whether
petitioners,
your case has been considered or not.
Lordship,
What is the rule?
Lordship,
What is the rule?
Lordship
Assam
may find
Secondary
it annexed
Education Law School Service Rules.
Lordship.
What is the provision?
Lordship, it's on page number 36.5.
Where it is?
May I read, Lordship?
Point five.
Recruitment to the post of senior assistant in the office of the higher secondary high school shall be made by promotion on the basis of district-wise seniority cum merit in the manner provided under Rule 7.
So,
Lordship, they have relied upon this rule, but this pertains to government schools, Assam Secondary Education Government Schools Service. This is not provincialized schools. There is a different rule for that. Lordship, in that their writ petition is flawed.
Let them file the affidavit.
this is a which place?
Lordship,
Which place?
Sivsagar, district Sivsagar.
Is not a government higher secondary school.
It is, Lordship.
No, it is a provincialized school. Provincialized schools. All these are provincialized schools.
Okay. Heard Mr. So-and-so, for the petitioner. Mr.
SS Bolwa for the rest, private
respondent.
respondent.
Counsel for respondent number
4 to 10.
4 to 10. Respondent is granted for the 3 weeks time to file affidavit.
Lordship, the secondary department had taken 4 times already.
The state also may file their affidavit in the winter. This after 3 weeks.
Date. God bless.
Yes, so my school is inadvertently dropped from the DICE data,
So
the year
what can be done? Yes, who is appearing?
Lordship, I have sent the affidavit for vetting. Lordship, may take it up next week.
Heard Mr. So-and-so, learned counsel for the petitioner. Mr. D. Chaudhary, learned standing counsel.
For SSA.
For SSA, submits that he may be granted further a week's time to file affidavit in opposition. List after, list in matter after 2 weeks.
God bless.
Meeting complete.
Lordship, respondent number 4 has appeared on the. Lordship, respondent number 4 has filed their Vekalatnama recently. Whether they want to file their affidavit or not.
Heard Mr. So-and-so, learned counsel for the PSA.
Lordship, I'm for the respondent number 4, but I have to get instruction from my senior.
On the prayer of MS So-and-so, learned counsel for the petitioner. Further 3 weeks time is granted to file affidavit.
Lordship, may I pray for a fixed set because this is a senior citizen. His
What
news
is
are
the
pending.
matter?
Lordship, the matter is, Lordship, he was an employee of Hindustan Paper Corporation Limited. There is an admitted due of 1 crore rupees that has been admitted. Now, Lordship, the only difficulty is the official liquidator in the list sent to the government did not include my name. Now the tussle is between them as to who will pay. In that I am stuck. But the dues are admitted.
So you file your affidavit.
We have filed, Lordship. We have filed.
Saying what? Saying what?
We saying that we being the AIDC is only implementing authority as per this.
Then who has to decide?
AIDC says in the list. AIDC says in the list submitted by the liquidator, my name was not there. Subsequently, the liquidator says that it was erroneously not included, but my name was there. Now the IDC says that since you had not given us the name, now you decide upon it. And the liquidator says that your name was there, therefore AIDC is required to pay.
So who is liquidator is a
The
party?
liquidator is respondent number 4.
Okay, you file affidavit.
Should may I pay for a fixed date considering this?
That's it. After 3 weeks.
Obliged, Lordship.
May I please your lordship?
Yes.
Case relating to compassion appointment, lordship, here my father expired on 19/5/2003, leaving wife, 2 daughters and the petitioner.
So
Initially, mother applied.
yes,
At that point of time, I was minor.
yes.
I attained majority in the year
So what
2006.
is to be done today?
I am praying for
Who is called the respondent?
final disposal. Final disposal, lordships.
Lordship, because of some
Affidavit
medical
they filed.
emergency, my senior had to leave.
Who?
Mr. BK Singh,
Is for?
Affidavit- They have
FCI,
filed their affidavit also. I
Is for?
don't tell.
FCI Lordship.
Okay, FCR.
Matter be taken up on Friday,
On next-
Mr. So-and-so, learn
on next
counsel for-
Tuesday, Lordship.
MS so-and-so, learn
Friday Lordship.
respondents appearing on, appearing on behalf of Mr. BK Singh. learn
Yes,
counsel
Lordship.
for the respondent. Submits that Mr. BK Singh had to leave the court premises
On
due
10th
to
of June.
emergency, due to personal emergency, therefore press for listing of the matter. Press for listing of the matter after the praise allowed list after a week.
Obliged, lordship.
Obliged Lordship.
You take the.
Yeah, Lordship, the last occasion, respondent says,
Yes,
taken
affidavit.
few-
Yes, respondent, who is the respondent?
Secondary education department. Secondary education department.
Where's the question of appointment, provincialization? Where's the provision?
Lordship, provincialization, page 20, my lord. Page 20, my lord,
Where is the provision for provincialization of the post of junior junior assistant?
yes, my lord.
Where it is? Which provision?
Lordship, under 2018.
Yes. Madam, who is appearing? Are you appearing? Who?
Secondary.
There is no standing counsel. You file affidavit, not Mr. So-and-so, land counsel for the person.
Last chance. my lord.
Only prayer of Mr. D. Majumdar, R. Majumdar, land standing counsel, secondary education, for the 3 weeks time. is granted. Yes.
23.
May I please, lordship?
My lord, this is 27. My lord, here in this matter, my lord, I have received instructions.
Saying what?
Lordship, on 23/5, a hearing was to take place, and accordingly, that hearing had taken place, where all the stakeholders were called in. But my lord, what has happened? A lot of anomalies have been found in that particular hearing. So therefore, my lord, an inquiry has been investigation has started, my lord. So sometime the department has sought, my lord, at least 3 weeks, my lord, because there are glaring irregularities and anomalies, my lord, which the department will produce, my lord. So some time may be given, my lord.
Petitioner has misappropriated.
Yes, your lordship. On the last order, your lordship sees 23/5, hearing was supposed to be given, and the hearing was given, my lord.
There is a time and again there is a direction.
Or Mr. So-and-so, land counsel.
My lord.
Mr.
A. Fukan, my lord.
A. Fukan, land standing counsel.
My lord, elementary education.
Elementary Education Department submits that the hearing fixed on 23. No, hearing
The hearing took place.
had taken place on 23/05/2025 by then
Lordship may submit.
after hearing
Yes, eh?
hearing all the concerned stakeholders, it is found that there are serious anomalies.
My lord.
Anomalies. Therefore, further inquiry is to be caused. Mr. Accordingly, praise that further 3 weeks time may be granted to complete the inquiry process, right?
My lord.
Praise the Lord, list. This,
3 weeks.
after
Kindly
3 weeks,
date will
on the
be
next day,
present,
the
submission.
Learned Council, the standing council shall place the report of the inquiry.
Well,
We'll see.
because this petition is related to area salary, Lordship.
My lord, the petitioner has done, my lord, many manipulation of records also, my lord.
Yes, we'll see.
You see, man.
Lordship, because prior to that, there was
Let's next.
Deeply applied.
Lordship, hearing this matter, may I pray for 2 weeks' time to file my affidavit,
The
Lordship?
prayer of
I have
Objection.
objection to that, because
Aye.
your lordship, what has happened? Your lordship will kindly see the last prayer, last order of this honorable court. Why I'm saying that,
This-
this
this is the
allegation,
matter on next Monday.
yes, that was there, they did not. Anyway, what I'm trying to point out, the allegation was that there was no notice served upon me before terminating my service and without giving me any hearing, your lordship,
Yes.
personal hearing. This was the reason, this was taken in the, initially in this case itself. They
So
filed an affidavit, I'm telling you.
Yes.
They filed the affidavit and they kept quiet in with regard to serving of the notice. They were making some other, your lordship, grounds on that. Now suddenly when this case was listed on the last prior to the last occasion, they came up saying, no, we have given a notice to him. And they were directed to produce the notice by an affidavit. Why they are not doing it for the last so many days, your lordship?
No, Lordship, that order is of 21st, Lordship. I'll file, Lordship,
No,
on
The
behalf of.
then
petitioner
let them
has
produce that.
indeed given notice and given some time to file the construction. Yes.
That is it. This was the allegation in the very beginning.
Hmm.
From the very beginning, the case was only that you have not given notice, without notice and without giving an opportunity of being heard, you have been terminated from service. And that is the allegation. If you would have given notice at that point of time, it would have been brought on record on the affidavit they have filed. Obviously, that would have been.
Lordship, that affidavit has
Just
been
let
filed.
me complete, please. What
Yes,
I'm
okay.
trying to say, don't make submissions.
I'm
when
not
I'm
interrupting.
Then what has happened? They did not, they filed an affidavit. The affidavit was filed, not a single.
Lordship, that
whisper.
affidavit has been filed on behalf of the principal, Lordship, not on behalf of the department, Lordship, not on behalf of the Director of Medical Education, Lordship. I'm praying for 10 days' time, Lordship. I'll file my affidavit, and he was not having the requisite qualification.
1 week.
Yes,
Where is
Lordship.
Monday? Next week.
Yes,
Not
Lordship.
As a
fix it
MS.
next week,
MS.
and at least if they are not filing an affidavit, they may produce the notice. That's it.
And Mr. Vice Mandan, Council for the Petition. Mr. D. Upamanya, non-standing of the Health Department. Press for further a week's time to file affidavit as allowed by this court on 21/05/2025. Right, a lot. This is the matter. After a week, the petitioner, the respondent to file the affidavit as sought
Lordship has fixed it on,
1 hour before. Week.
not when,
Highly appraised.
when date.
After a week.
Yes, Lordship may kindly give a date. This is something that is going on like this here. Kindly give
It
a
will be
date.
listed. After a week. This is the
Yes,
list.
after a week, kindly give a date.
Highly appraised, Lord.
Date, Pradeep.
Lordship, in this case, on behalf of the PWD, we have sent the affidavit for waiting. Lordship, may take it after a week.
Heard Mr. Swenson and Council for on the prayer of Mr. B. Chode, Land Council for the petitioner.
PWD.
PWD, Islam is telling at PWD, for the 3 weeks time is granted for filing affidavit.
That matter can be taken up for disposal, my lord.
Why?
Convenient today or any other day.
Affidavit is.
So affidavit filed?
Pleadings completed.
Yes.
Not, okay. So what is the case?
My lord, termination of service, I'm challenging the first show cause notice. And the
Will-
notice
will
given
the
after the inquiry.
record will be required?
Records required. It's covered, otherwise it's covered. Records I have already annexed with the petition, whatever.
Anyway,
That's it.
after
After 2 weeks,
termination.
notice.
Ah,
After
after the inquiry.
After the.
Yes, we call for the record. Did you put it there? What Mr. Ahmed in that line consider for the petition? Admit this petition. Is for hearing after 3 weeks. 3 weeks.
3 weeks.
Mr. So and so to put in the record in the next step. 3 weeks.
Obliged. Deeply obliged.
May I please, your lordship?
Yes.
Lordship, we have sent the affidavit for vetting.
Mr. So and so on the prayer of Mr.
D.
He
Musari,
was learned
stainless, secondary education.
Secondary education for the 3 weeks time is granted.
Lordship,
Oh,
next week, your lordship.
2 weeks.
Lordship,
Then two.
obliged.
Lordship, there will be timing, which is in another.
What is the matter?
I'm for number 6, your lordship.
Affidavit.
Affidavit filed, your lordship, today.
File. Okay.
It is.
So, what is the matter?
The case record, your lordship.
Huh?
It is filed today, your lordship.
Yes, it is here, I think. Affidavit on behalf of respondent number
6.
You are who are. No, additional. No, this is by the petitioner.
Yes.
Huh?
Yes, Lordship.
Additional affidavit.
Yes,
You have filed the counter affidavit.
I have filed the affidavit in opposition, your lordship.
Yes,
In-
not the counter affidavit. Not the counter affidavit.
Not the,
On behalf of, who is respondent number 6?
respondent 6 is the president of water user committee, your lordship.
There is no respondent number 6.
Yes, your lordship.
There is, where is this?
Yes, there.
There is no respondent number 6.
Yes. It's
Only respondent number 5.
Subsequently, it was made party, your lordship.
Is it?
Yes. Subsequently made party.
So what do we want?
Lordship, timing, Lordship.
What is the matter, sir?
Lordship, some Jal Mitra matter.
Appointment of Jal Mitra.
Jal Jeevan Mission. There is appointment
Jal
of Jal
Jeevan.
Jeevan Mission.
Joel Mitra.
Yes, yes, Lordship. A senior is in busy, busy in another code, Lordship.
Hmm?
Senior is busy in another code, Lordship.
You argue the matter, it's there.
No, affidavit compulsory is. Huh? Copy कौन है बंदे में? कुछ है दो लेटर. इसलिए मैं तो कॉपी कौन है? मतलब मैंने बात करी थी कि मेरा भी हाँ. तो कभी नहीं दी मुझे. अभी दिलो.
Joel Mitra.
Yes, yes.
What is your stand?
My lord, okay, the writ petition was filed on 25 of 2024, your lordship. But by order dated 1/2/2024, the one Jahangir Alam was appointed as Jalomitra by the user committee, your lordship, who is countersigned by the sectional officer.
He has been appointed as
Yes,
Joel Mitra.
He was not implicated in this case as party respondent, your
That's what
lordship.
I'm saying. He has been appointed.
He has been appointed.
In fact, whatever petitioner, he's working as a laborer.
Laborer, yes.
He's working as a laborer still.
But
See, what he's saying is, I am working at as a labor in the department, having some experience. So as per the guideline, the appointment of jail metro has to be as per the guideline, who has the kind of the experience. Therefore, he should be appointed. He should be considered for appointment. That is his pleading.
My
Like
lord,
his system, those things.
that,
Yes.
person is not included in this case, your lordship. as-
Forget about it. It's good for, who are you? You are the appointing authority.
No, your lordship.
Who you are?
Myself, another secretary, president, and which is countersigned by the sectional assistant, your lordship, of that department. Three persons are here, your lordship.
There's no affidavit. The affidavit is not there.
Affidavit is not tagged with the.
When did you file?
It is filed today, your lordship.
Huh?
Today. It is not
Obviously.
tagged with the case
Or
record.
Mr. So-and-so, learning counsel for the petition. MS so-and-so, learning
Eh,
counsel
Email.
for the respondent number 6 who has been impleaded subsequently submits that she has filed the affidavit in implementation on behalf of respondent 6 today. However, the record doesn't, however, it's not tagged with the record. If this is the matter after 2 weeks, the rest is to verify and take the affidavit of position with the records. Tell your senior no case.
Your lordship, the petitioner lordship assailed the provincialization order of the respondent lordship. Lordship will find the provincialization. Before that, lordship, they are supposed to file it. Repeat, lordship.
What's wrong with the provincialization?
Yes, sir. Lordship will find that order at page 56.
56.
Page 56 on 7/1/2015.
Yes.
This provincialization order issued in respect of the respondent number 7 based on a district scrutiny committee's recommendation. Page 56, Lord.
Yes.
So subsequently, lordship, what happened on 7/1/2015, the district scrutiny committee cancelled the recommendation made in favor of the respondent number 7. That cancellation of the recommendation order, lordship will find at page 60. Lordship, this order was issued. Lordship, may kindly see the third paragraph of page 56. And also read the minutes of the Golaghat District Scrutiny Committee held on 7/8/2014. The District Scrutiny Committee in its meeting held on 7/8/2014 resolved that
Sunil
Mr.
Kakote. You are Sunil Kakote.
Yes.
Is
it
the
renewed
arts of Monitor.
to so-and-so. So in view of the facts stated above, the service of so-and-so is hereby provincialized against vacant post of third assistant teacher when provincialized by order number so-and-so. Now, lordship, on 7/1/2015, the same district scrutiny committee of the Golaghat district have cancelled the recommendation made by them on 7/8/2014. That cancellation order, lordship will find at page 60.
Anyway, court has directed to resolve the issue.
Yes.
Right? So now,
Then you put to challenge this provincialization order on the ground that the director by this order saying that on the recommendation of the district scrutiny committee of 7/8/2014, the service of the respondent number 7 was provincialized. Now
no,
subsequently,
in view of the facts stated above, the service of the is hereby
Provincialized.
The skill pay of so-and-so. It's not only in its meeting.
No,
held on
third part.
7/0/07/08/2024.
That-
14.
14, 7/8/2014.
Is
Lordship,
almost
kindly see
10
the
years.
Third paragraph. Third paragraph of the provincialization order of the director.
Yes, it says
7/8/14.
held resolved that Miss so-and-so is almost 10 years senior to this
Yes.
so-and-so.
But
Yes.
this was held by the decision of the district committee of
Where it is,
7/8.
where it is.
7/8/2000, that is not lordship available with me. But subsequently, this provincial recommendation order of 7/8/2014, this has been cancelled by the same district scrutiny committee. So
It's all
on
right.
that ground, lordship, I have
Then whether this cancellation has been, by cancelling the recommendation,
No, that this.
whether
subsequently
your
this-
name has been given.
Subsequently, while I assailed this order has been set aside.
Which
That-
one?
That I'm coming to, this order of 7 of 2015.
This has been set aside.
Yes, set aside.
By
I'm
the
coming to
court.
that. Yes, by this. court.
Then come to the main issue.
Yes, that lordship set aside order lordship will find.
Is the party here?
Yes, yes.
Who appears for her? Then finally, what happened?
Then matter will remand back to the authority, then lordship will come to page 67. Page 67, the order of the honorable court.
Sunil Kakoti.
That's from the order dated of 28/7/2023, page 70.
70.
70.
Yes.
Page, now lordship come to page 71 on bottom lordship paragraph number 4 on a consideration. I'm coming to the only relevant portion. On a consideration of the order dated 26/2023, the first ground that the case of the petitioner could not be considered on a humanitarian ground is not projected in the direction passed by this court in the order dated 8/11/2019.
So what happened thereafter?
Lordship, thereafter,
Court has remanded back.
yes,
Huh?
remanded back. This is said by setting aside the order of provincialization in respect of Resolution number 7, the matter will remand back.
Yes. So
Now again, lordship, the impugn order passed on 15/3/2014, saying the same thing. They are supposed to review the earlier order in terms of the section 24 of the Provincialization Act of 2017, but that was not done.
it's 15/3/2024.
Yes,
Same thing.
same thing. They have reiterated the same thing.
There shall be additional post in the same subject in school if the minimum of students appear in the assessment. The service of children cannot be considered for due to non-fulfilling eligibility criteria laid down in the. No, you have been rejected that you don't fulfill.
But rejected on the same ground. In the earlier occasion also, they are saying that lordship, he is senior and additional teacher. But this time also, while this setting aside the provincialization order of Resolution number 7, this honorable court. That's why initially they have submitted that they are supposed to file affidavit, but they have not filed affidavit.
If the instructions are awaited, your lordship. Lordship,
How
he
many
was-
days? What Mr. A, the learned counsel for the petitioner.
D. Musari, your
On the
lordship.
prayer of Ms. D. Musari, the
Secondary.
taking counsel in the education. For the 3 weeks time. after election.
But the date may be fixed.
But this impugn order says you are found to be not eligible under the.
No,
provisions
the
of
recommendation,
2017.
my ground is that the recommendation based on which this provincialization order.
No,
issued,
it's
that was
okay.
cancelled.
No, apart from that has been set aside, but then the facts remain that you are junior to her.
No, but prior to that, lordship, in 2011 itself, this Resolution number 7, lordship.
Are you saying that you are senior to her?
I am not senior, lordship, but in 2011 itself, the Resolution number 7 has been removed from the survey. Those things are not considered. And number one.
What
Secondly,
about you?
lordship?
What about you? Have you
He's
been
been-
I am the
continuing?
assistant teacher, lordship.
Still continuing?
Okay.
Lordship?
Still continuing?
Still
Yes,
continue.
I am continuing.
What about her? She's also continuing.
I think also he retired, no? During pendency, he retired, lordship.
Then what's there? You consider his case.
No,
The ground is that
not sure.
she was senior to him,
Yes, yes.
therefore.
Yes, your lordship.
Now, once it is, once the post is provincial, is a personal post or what?
Personal post, your lordship.
Once it is retired, there cannot be.
Yes, yes, your lordship.
Is it so?
Yes, your
No, this,
lordship.
this provincialization was done, lordship, under the 2011.
Acha.
11.
In 2015 order issue,
Hmm.
while the act was in force, lordship.
Hmm.
And this order of
So what
2019.
can you, how, under which rule you can be, act you can be provincialized?
Section 10, lordship.
Can be.
Yes.
Under?
Under the Provincialization Act of 2011.
No, 11 we cannot. now.
No, your lordship.
That has gone now.
Hmm.
That has gone now. And the person against the post which you are
And secondly,
claiming,
lordship,
she
the,
has also been retired from
while,
service.
while the order is setting aside by this honorable court, there is also a direction is given to the director to review its earlier order in view of section 24 of the Provincialization Act of 2017. That
Ah.
was also not done.
No, 17 we can understand, but not 2011.
But that was not done.
Okay. Let's see. We'll see.
But the date may be fixed.
3 weeks.
After 3 weeks, the date
But
may be-
continue, yeah, it's okay.
The
Yes.
lordship, this is the 5th round of
List
litigation.
after 3 weeks,
The date may be fixed.
it will be listed. That's why cause list is there. You file it from cause list.
Obliged, sir.
That is it.
May I please?
Yes.
My lord, kindly peruse the last order, my lord. Earlier,
Mr. A. U. Uddin.
3 occasions they are still not filing affidavit, my lord. It is, my lord, the petitioner is a retired teacher, my lord. He is claiming his service benefit, my lord,
Okay.
retrospectively.
Regular teacher. Somebody has filed affidavit. Who has filed this?
That is, he headmaster.
Okay, headmaster is nothing to do with.
Headmaster has admitted the fact, whatever I have, but state affidavit is necessary. They are not
Yes,
filing.
yes, heard. So and so, who is appearing?
Secondary education.
AI, Artificial Intelligence Uddin. Huh?
Yes.
AI Uddin, Learned Council for the Mr. Anmajumdar, Learned Standing Council. Secondary Education Department granted for the 3 weeks time to file affidavit.
The date will after, even after vacation, my lord, the date kindly be fixed, my lord.
You know.
I am praying for a
3
day.
weeks.
I am praying for after.
3 weeks. Yes.
Lordship, this matter is a family pension matter, your lordship. They
Yeah.
have filed affidavit today, your lordship.
No, I'm for respondent number 6 and 7.
So 6 and 7.
Yes, I'm for bank.
Huh?
I'm for bank.
Yes. Who is the main respondent?
Respondent number 9, your lordship.
Who is 9? Have you filed the affidavit?
I have filed the affidavit today, lordship.
Okay. Not Mr. So-and-so learned council for the police. Mr. So-and-so learned council for respondent number 9 submits that he has filed the affidavit today. Our is not like with the report. It will be verified and take it with the records. Just after 3 weeks.
After 1 week, lordship.
3 weeks.
Obliged. This is a compassionate.
2
family
weeks.
pension. Obliged.
Lordship, this
No
IA is for,
affidavit.
IA is for impleadment, Lordship. I'm submitting on the IA, Lordship. IA is for implead. I filed an IA
Yes.
for impleadment of the Commissioner and Secretary to the Government of Assam Finance Department and the NHAC Haklong as the respondent number 5 and 4.
Any objection?
Lordship, I have got no objection.
Heard, Mr.
I'm appearing for the PWD.
FZ Mojumdar.
FZ Majumdar, then concept of the applicant, huh? And Mr. B. Chaudhary,
For PWD.
then standing counsel for, then standing of the PWD. By next, filing this application, the petitioner pays for impleadment of the Commissioner and Secretary to Government of Assam Finance within Record Budget Department, Budget Record Clause Department, and the Principal Secretary NHAC in Hatlam as respondent number 4 and 5 in the connected writ petition number 4981 of 2024. Next year. Having considered the submissions of learned counsel for the petitioner and also the grounds of impleadment. As ever in the application, as well as with prayer not being objected to by learned counsel for the learned standing counsel for learned standing counsel for the respondent. I deem it appropriate to allow this application as the petitioner, as the proposed respondents. The proposed respondent, the proposed impleadment of both the respondents and respondent number 4 and 5 appears to be a necessary party for proper adjudication of the writ petition, connected writ petition. Accordingly, the IA stands now. The the commissioner and so both the name be implemented at respondent number 4 and 5 in the connected writ petition being WS WPC so.
Should I file amended cost item?
IA stand disposal. Allowed in disposal. Next paragraph. In this thing, writ petition, in writ petition, the in view of the order clause so and so, Mr. So and so to file amended cost item. Therefore, the registry to incorporate the newly included respondents as respondent 4 and 5. The petitioners to take steps for notice upon newly included respondent 4 and 5. Standing counsel is there.
Yes.
So you may.
I'll handle it.
Through the standing to the standing counsel, of the newly included respondent number 4 and 5. This will be better instead of formal notice and all. All right.
Lordship, the names may be shown in the cause list.
First, they let him take this thing. Yes.
My lord, may I please, Lord?
Yes.
My lord,
I am petitioner. May I please, your lord. In this case, lordship, my issue before lordship is very simple. The petitioner should reverted back to the original post of Forester 1 without following the due process law, without following FIR, lordship. This is my case.
What is to be followed?
Now,
Lordship,
for reversion.
We were the Forester grade 1, lordship.
Yes.
As per rule, lordship, the Forester who secured first, second, and third position in the departmental training have to be considered for the next promotion of deputy ranger. Accordingly, the petitioner before lordship were promoted to that post lordship as a deputy ranger. Thereafter, at the same time, forest guard were also promoted to the Forester 1. Both Forester grade 1 and the deputy ranger were demoted to the original post without even serving any show cause notice. We were not afforded any opportunity being heard. On that ground, lordship, forest guard opposed before this honorable court. And this honorable court has set aside that impugn order and relegated the matter to the departmental authority to give them promotion and again to show cause them if so required, lordship. On the same parity, lordship, I am before lordship, we were promoted to the deputy ranger, we were demoted back, reverted back to the original post without following natural justice. So we may be also considered in that line, lordship.
Same post, same reversion, same
order. No, not
same department.
My lord, before deciding the question of natural justice, my lord, it is to be decided whether their selection to the post of deputy ranger is as per law or not.
Yes, department will
No,
decide.
no, my lord, already after giving them promotion, my lord, department has demoted them again in the original post because their promotion was not granted as per law, my lord. So law provide for seniority cum merit, my lord. That was not followed. Now, my lord, here in the writ petition, item number 39, my lord, on the last occasion, this honorable court impleaded us, the private respondent, as a newly impleaded respondent, my lord, and accordingly directed to, my lord, submit the amended cost title, my lord.
You have submitted.
So already they have submitted, my lord. Let them submit the copy, my lord, provided a copy of the cost title along with the writ so that we can file our affidavit, my lord. Now, my lord, item number 40, let me finish. Now, item number 40 is the file by the same, my lord, person. They are also a forester grade 1. They are also entitled for the promotion to the post of, my lord, deputy ranger. Now, their case has not been considered. So we have filed this writ petition, my lord, item number 40.
You are for item number?
Item number 40, my lord.
40.
So we are also, my lord, seeking, my lord, asking for the same promotion, my lord, to the post of deputy ranger.
You are similar to him?
Yes. No. On the basis of, my lord, yes. On the
Are
basis of.
Are they party in this writ petition?
Yes.
Item
we are not bad
item 39, my lord, we have filed an implemented petition, my lord. This honorable court allow us So accordingly, we have been impleaded, my lord.
Yes.
So now we want to file our counter, my lord, in the item number 39.
Then item number 40.
40 is, my lord, filed by us, my lord.
We are not
Are
made
they
party
party?
because.
No, my lord. My lord, here, we are not saying that, my lord, he is not entitled or I am not entitled.
Yes, that is-
We are saying that all are entitled, my lord, but promotion should be granted as per seniority cum merit, which is provided under Rule 2005.
No, I will.
Are you senior?
Lordship,
Are you senior to him?
my channel of promotion is quite different and his channel is quite different.
That's why I'm saying,
His
let us,
mistake is
let
honorable,
us
I
allow to
think
file our counter, my lord.
Rule,
Ask
Lordship.
Mr. So-and-so, learn counsel for the petitioner. Let him, since you have,
Yes.
since they have been impleaded,
They have been implemented way back in the March, Lordship, and today is June, Lordship. He has not filed affidavit.
have
Lordship.
you given the copy?
No, my lord,
He,
till then
no,
not.
Lordship. He has implemented themselves, Lordship.
Sir, you-
What is the necessary for giving?
You-
I will provide, Lordship, but it should not be the ground for delaying, Lordship, filing.
No, 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 no.
Because they
Mr.
themselves.
So-and-so, learn counsel for the petitioner in the item 39.
39.
To furnish the copy of the writ petition.
Along with the, my lord, amended cost title.
No, copy repeat there is got, Lordship.
What is the amendment was there?
My lord,
That will
because
be there, that will be-
Lordship, only the cost title name of those petitioner who he implemented.
Furnish the copy of the writ petition.
Copy they have received, Lordship.
WPC 5586 of 2024. Heard Mr. So-and-so learned counsel for the petition in WPC 5586 of 2024. Learned counsel for the petitioner to furnish the copy of the writ petition.
Lordship, they want only
to-
amended cost.
Just wait to Mr. So-and-so
K. Singham.
who so-and-so learned counsel for respondent number
My lord, 4 to 30.
4 to 13 who has been who have been impleaded subsequently. Mr. On the prayer of Mr. So-and-so Singha, further 3 weeks time is granted to file affidavit. Then in thereafter in Mr. So-and-so in the WPC 544, Singha is not a party there. List along with this. Listing the matter with WPC 5586 of 2020.
My
Lordship, let it be 2 weeks after.
For 3 weeks. 3 weeks.
double.
Well, in this case, I'll be filing affidavit, my lord. I have already served a copy, my lord. We'll be filing.
That's right.
Well, we have received the copy, my lord,
Huh?
but your lordship may fix a date, my lord, because, my lord, the case is pending since long, my lord.
Sorry, my lord.
As does.
Yes, my lord, sorry.
Standing counsel or standing counsel
This is
for
higher education. my lord.
higher education.
My lord, in this case, your lordship will find, my lord,
Further
That
3
the-
weeks is granted to file.
that the petitioner, my lord, despite having, my lord, uniform, good academic, my lord, record, my lord, the person who has got, my lord, the less mark than the petitioner.
3 o'clock next case.
My lord, your lordship may
Why
fix
not
a date.
disposing anything today?
Correct, my
Granting
lord,
them time
correct.
to file affidavit.
Lordship may fix a date, my lord, it's pending, my lord. Otherwise, your lordship will find, my lord, there are altogether as per the advertisement.
Can it be decided without their affidavit?
That is why I am submitting, my lord. Date may kindly be fixed, my lord. After a week, my lord, or 2, because, my lord, because, my lord, we have to see, we have to go through. If required, my lord, we have to counter. We have to file a reply to that, my lord. That is
2
why, my
weeks.
lord, your lordship may fix a date, my lord, after 2 weeks, my lord. Any date, my lord. In between them, my lord, we shall complete our pleadings. Then that case may be disposed of. That is my thinking.
Let them first try.
Yes.
We'll see.
So a date may kindly be fixed, my lord.
You don't need permission of the court to file affidavit in reply. You
Correct.
file as
Yes.
soon
I'll
as
file-
they file the affidavit, you file your affidavit.
I'll file, my lord. I'll have to, my lord, because there are some certain, my lord,
Okay,
points-
we have
points
granted only 2 weeks. Next case. Thank you.
My lord, date may kindly be fixed, otherwise
It will be listed after 2 weeks.
my lord.
Sir, can I have it next week, my lord? I am appearing on behalf of respondent 23456.
Okay.
And let it be any other day in next week, my lord.
Okay. Who is,
Yes, please, the petitioner.
Affidavit has been filed, my lord. We have also filed reply.
Reply
Small
file.
issue, my lord.
it's all complete. Pleadings completed.
Complete, my lord. Let it
Small
be.
issue.
Heard Mr. M. Sir, Land Council
sorry.
for the petition, and Mr. Escoto Land Council appearing on behalf of
23456.
respondent number 2, 3, 4, and 5. As agreed to by the Land Council for the party, with this matter after the wait.
That may be fixed, my lord. Small matter, my lord.
What is a small matter?
You will
There's
not-
no small or
Yes,
this
ma'am.
big matter. All cases are same.
Only that may be fixed. If
After a week.
My lord, second round of litigation, your lordship will kindly come to page 41.
Yes. Durgeshwar Das,
Yes, my lord.
40.
Page 41, my lord. First round of litigation disposed of on
Saying what?
1st of 23. A small order, my lord. Everything is detailed, my lord.
And on consensus, the writ petition dispose of directive so and so, or before the disposal after following due procedure is program and so and so. Yes.
My lord, after this, when nothing happened, we approached this honorable court, and after several occasions, my friend has filed an affidavit where your lordship will find at page 48, annexure A.
Yes.
Well, I'm skipping this formalities. The committee observed that as per Provincialization Act so and so, the maximum 5 teaching staff as per so and so shall be provincialized. The service of the 2 senior most assistant teachers school have been provincialized as per so and so. The petitioner was 3rd assistant teacher from the seniority as per approval order number so and so. After discussion and considering the guideline of the government, the committee unanimously decided not to recommend the petitioner name for the provincialization. Interestingly, your lordship will see no copy is handed over to the petitioner, my lord, as of this date, my lord. First of all, this is violation.
This has been brought on record. You challenge this.
My lord, this was.
We'll ask them to furnish the copy right now.
The copy is already given.
Now we have given, my lord, we have filed an affidavit.
We'll grant you a liberty to challenge this. Because what they are saying is, as per the norms, all right, wrongly there may be delay, there may not be properly or improper consideration, but consideration has been made and wrongly, rightly taken a decision saying that you cannot be provincialized because you are 3rd in number.
Senior most teacher.
Whether it is possible or not, you think about it and challenge this. Because that time, at the point of time, there's no reason as such. We'll close this writ petition. Liberty to challenge this.
My lord.
Heard Mr. So-and-so and consent for the petitioner, who clearly submits that in view of the order dated 19/04/2025 issued by the Additional District Commissioner within bracket in charge I/C in charge and page 48 was come chairman of the committee by which the
Chairman of the committee.
grievance of the petitioner has been rejected. Although, the copy has not been served with the petitioner, the petition may be allowed to be withdrawn with a liberty to challenge the order dated. No, not order, minutes.
Minutes of the meeting dated,
Oblique decision, not order, issued by this one. If so advised. Mr. Epukan, standing counsel.
Elementary
Education is present. Consider in view of the exchange clause has not just is withdrawn with a liberty aspect.
Deeply.
In this matter, the petitioner had participated in a selection process and he was declared successful in the entire recruitment test. The results were withheld only on the ground that they wanted to verify the credentials regarding my fingerprints and signatures.
Yes.
For their affidavit matter at page 122.
Saying that your name has been finally recommended.
Yes, yes, but they are not now
So what is doing you
issuing their appointment letter.
Your Lordship, we have already filed the affidavit and the.
Yes, you have said
the LPI
finally all this settling.
Yes.
You have finally recommended. Only you have to appoint them now.
We're still awaiting instructions from the CFPB.
No, the CFPB report and everything has come at page 123. They say that I'm being recommended at page 122. The affidavit, they are trying to mislead by 2 points. I'll read it out.
Who has to appoint?
The appointment has to come from the group center CRPF matter here. Respondent number, if I'm not wrong.
This is the recommendation, right?
Yes, madam.
Kindly refer to as desired board procedure along with original document dossier in respect to the or enclosed here for sanction. So your name is
at page 122, my lord.
No, 123. What is 123?
Page 123. I am at serial number 9.
Yoti Moy Kolita.
Yoti Moy Kolita.
Page 120, where it is? What is
Page 123, I am serial number 9.
What
is page 105.
No, 122, what you are saying?
122 is the recommendation that is regarding the Jyotimoy Kolita on the second column. Lordship will find my name. The second column. And if Lordship comes to the last column, last para. However, board is of the opinion that the writing, signature, and even thumb impression were all of one and the same person, hence fit for appointment. This is what they have sent
in respect of you.
Yes, Jyotimoy Kolita. In the second column, my name is there, my roll number is there in the first column.
Balaram Kolita is your father.
My father.
Okay. Our board is of the opinion that the writing, signatures, and even thumb
impression were all of one and the same person. Hence fit for appointment.
Fit for appointment. Yes, only this is it has to be approved.
It has been approved. People have been appointed in 23. I am waiting till 25, my lord.
No. This is the findings,
my lord,
and the recommendation to be for appointment.
For appointment, yes.
It has been sent. Who has to approve it? Who has to appoint? Let us see.
That is at page 123. This person, my lord, the Deputy General of Police Recruitment Director General CRPF. They are sitting over the matter from 22.
Who is appearing for them?
He is appearing.
Your Lordship,
sir, it's your affidavit only.
But
it is your affidavit. You are saying that this, after all this consideration, inquiry and counter inquiry, whatever is there, the inquiry and all the investigation, you have to send it for. You found that it's fit to be appointed.
But for further verification.
Friday, appoint, approve or appoint by Friday.
Your Lordship will give us.
It's your affidavit. We're not saying anything. We're not deciding on merit. You have said fit for admission. I mean appointment.
However, there was some further.
It's a matter of your thumb impression. What was that called? Yes, Majumdar. What is that? What is the defect there? It's a thumb impression, something like that.
They said that my handwriting, thumb impression, they had to be re-verified because they were smudged. Originally, they said
in what?
In the recruitment process.
Yeah.
Physical verification.
So finally, it has been found to be her this thing.
However,
Friday.
Yes, Your Lordship.
You talk to them, get it approved, issue the approval. Our Mr. So-and-so counsel for the petition. Having noticed that the respondent authorities have clearly stated in their affidavit that after the prolonged investigation and verification, the petitioner is found fit to be appointed. Accordingly, a recommendation has been made for her appointment. Mr.
Zainaj Bora on behalf of Mr. S.S. Roy.
So and so, learned counsel. No, and in that case, we'll say Mr. Assessor, learned CJC to obtain instruction. To place the instruction by 06/06/2025. It is expected that the respondent authority shall approve and issue appointment order in view of the clear statement made in their affidavit. So just say expected. You tell him, SS Roy, seriously,
Lordship.
apprise him, your senior.
Absolutely.
Right?
Oblige me. Most of it.
May I please, Your Lordship?
Yes.
I thought Lordship kindly peruse the office matter 28/25. It
Yes.
says, my lord, answer notices have been returned back with a remark of addressee left, my lord. My lord, I may be allowed some time to find out the present addresses of the respondent one
Okay.
and two. so that
In
I
view
can-
of the office not dated so and so, office not dated 28/05/2025, reflecting the address that the answer notices have been returned in respect of respondent number 1 and 2 being addressee left, comma. 3 weeks time is granted. 2 weeks time is granted to take steps, appropriate steps.
I'm obliged.
Lordship, in this case, I am appearing for the respondent number 3 contender. Let
been
order
complied
has
with.
already been complied with, Lordship.
Yes,
Lordship, in the meantime, area she has received, Lordship.
And that PPO has also been generated, Lordship.
Last instruction he has forwarded me, Lordship. As per this instruction, she should appear before the treasury for regular pension, Lordship. That
So-
order is there.
so complied with.
Yes, complied, Lordship.
It is submitted at the bar that the no, MS so and so, learned counsel by the petitioner and Mr.
And PP doctor for respondent number 3, Lordship.
PB,
PP.
doctor. Learned counsel for respondent and Alice content number 3 have submitted at the bar that the order dated.
Order dated, Lordship, this one is 22nd.
No, the court's order.
Court's order, Lordship,
Your
dated 15/3/2023.
15/3/2023 passed in WPC
WPC
3473 of 2020 has duly been complied with. Accordingly, the contemporary instance closed disposal.
Obliged, Lordship.
No appears for the case. None appears to the petition, parties, and list after 4 weeks. Yes, complied.
Lordship, I am appearing for the respondent number 2, Lordship. I'll need 2 weeks time to file my affidavit, Lordship.
What, have you complied or not?
Lordship, in this matter, the secondary education department will have to make the payment, Lordship. We are the health department, we have already furnished the medical admissibility report, Lordship. But the
So,
petitioner has not
who has to
exceeded,
comply?
it is the Lordship. Yeah. Director. Director.
Who has to comply, sir? He or somebody else?
All respondent is.
Lordship, it is the director of secondary
Or
education.
Mr. So-and-so, learned council, Mr. D. Upamani. Upamani.
Yes, Lordship, for
Learned
two.
council for at least content number 3. Rest one is granted.
Only 30 days is given. After 1.5 years, it is in approve.
3 weeks time to file affidavit. Huh?
Highly.
Lordship, in this matter, updated instructions are awaited, so I
Right.
pray. Huh?
Complied. Have
No,
you
no,
complied?
not complaint, Lordship. Updated instructions are awaited.
Also there.
Or Mr. So-and-so and Mr. So-and-so should
Department
granted
is
further
given.
3 weeks time to obtain instruction.
Personal appearance going.
Huh?
Personal appearance also.
We'll see after 3 weeks.
Obliged, Lordship.
To obtain instruction.
Right, your lordship. This is order of 2023, your lordship.
Yes.
We are praying for
Compliant.
compliant, no? Lordship,
Compliant.
no, lordship, we seek them sometime. We have filed a rate of appeal, my lord. It's pending for the Honorable High Court. That day the IA was, my lord, heard. I mean, my lord, the delay was, I think, condoned, my lord, and sometime maybe again, because my lord, the outcome of that maybe is awaited.
Why we cannot? That we cannot.
Then,
We'll
my lord,
just-
otherwise,
we may grant you sometime to.
sometime, my lord, we'll then
whatever
try
you want
to
to do it, do it.
Sir will give us 2 weeks.
Or Mr.
Lordship would kindly say
2
order
weeks,
dated 25 for 2025.
Huh?
25.
M.H. Laskar, learned counsel for the petitioner. On the prayer.
2 weeks, 2
Mr.
weeks.
Fukan.
After filing of the contempt, they are
Yeah,
filing an
Fukan.
appeal, your lordship.
Yes, you will see.
We have the right, my
Fukan
lord, to file.
is granted further 2 weeks time to file appeal.
Already it is a contempt, your lordship.
2 weeks. Huh?
There was
2 weeks time to file appeal. Let them
Last
file.
occasion also 2 weeks were given.
Huh?
Last occasion also 2 weeks
Okay.
were given.
Today also we are giving. This way we
weeks.
said further. Further 2 weeks.
Further 2
We'll
weeks.
see. We'll see. Just filing a appeal will not do.
My lord, my lord. They should have filed an affidavit, your lordship. They are not
Yes,
filing
that's why
affidavit
we're
also.
granting
We'll file, my lord, we'll file.
2 weeks. Further
weeks.
2 weeks.
I'll pray for a date, your lordship.
2 weeks we'll see.
2
It
weeks.
should be listed.
Deeply obliged.
Yes, Boro, get it listed after 2 weeks.
Obliged.
As per office order dated 27/5/2025, the service is not completed.
They will
Lordship may
send this
kindly,
report for further 3
Lordship may
weeks.
kindly place it before a Lojima court. We can then there take fresh steps, then they will serve us.
When the last notice was issued? Okay, 11.
11 Lordship.
Yeah. The order is required.
Lordship may kindly place it before a Lojima court, plus there we can take fresh steps, then they can track the postal record.
Placed before the Lajima court, huh? For necessary steps. It will be done.
Hello, here sometimes is required, the process is going on, my lord, and joint committee has asked the director to spot verification and a spot report.
You don't force them to file a contempt petition. If you have some difficulties, why don't you file affidavit if you want some time? There has to be kind of thing unnecessary contempt. It's not a job.
No, my lord, actually, process is going on, my lord.
That's what I'm saying. If you have difficulty to comply with, who is stopping you for approach the court again?
No, my lord, during
When
the
the
process.
contempt is filed, you are trying to seek a time and all those. This is not proper. Anyway, I'm Mr. Swenso, and counsel for them. Next one on the prayer, Mr.
You, Sharma,
You, sir, Malan counsel appearing on behalf
sole
of
respondent.
Alice Contemptor. Further 2 weeks time is granted to file affidavit.
Yes.
You may complete within 2 weeks. What you are trying to say is you want some time to comply the court's order.
Yes, yes.
With 2 weeks you comply, then you file an affidavit that it has been complied. All right.
Lordship, I am appearing on behalf of conducting counsel Mr. B. Verma.
Yes.
Lordship, actually, in this matter, Lordship,
Is on.
Huh?
the
It is on
Indian,
like.
Indian Oil Corporation, Lordship,
Huh?
Indian Oil Corporation Limited, who is the respondent here, Lordship, has already filed an a SLP, Lordship, before the Apex Court, Lordship, challenging the order dated 24/11/2023, Lordship.
Filing will not do. Is there any order, interim order?
No, Lordship, as the Supreme Court is observing vacation, Lordship, the matter could not be listed.
No, no,
Lordship.
he
It
was
was
not-
filed on 15, Lordship. So I'm praying that Lordship may take up the matter after our vacation, Lordship. So we can apprise the
After
court.
2 weeks, you file affidavit, not for Alice contender.
Yes, Lordship.
Or Mr. So-and-so was granting 2 weeks time. Then counsel for the petitioner on the prayer of Mr.
W. Rahman on behalf of Mr. A. Sharma.
So-and-so, huh? W. Rahman.
On behalf of
appearing
Mr.
on behalf of
A. Sharma.
A.
Sharma.
Sharma, learned counsel for the Alice contender. Further 2 weeks time is granted to file affidavit. Right? Yes.
May I please your lordship? Lordship, area salary of the petitioner he had not received.
Lordship complied with it.
Comply.
No, lordship, he had not received the area salary. Petitioner he had not
Lordship,
received.
it has been sanctioned from the commissioner to the proposal has been made to the,
What is the order? Let's see the order.
Page number 12, operating page is page number 15. Paragraph 3, page number 15, paragraph 3, lordship.
The grievance of the discord is he has not been paid his monthly salary for federal supervision and there is a petition. Praying for release of payment is something different. Only your representation has to be considered.
yes, Lordship.
Lordship, representation is regarding my area salary. lordship.
Yes. They have considered and they have processed it. You will get it. Madam,
No, I have not received it.
you will get it. I'm saying, I'm not saying that, I'm not saying that you have received it.
No, lordship.
Lordship, the relevant order would be at page 4, wherein the representation has been
Where is this?
Apply করা কি দিছে?
more soft copy. to review.
Order.
Yes, Lordship, order.
Have you given that thing, this disclosure station record?
In the order, it was
Please, you
stated
can-
2 duration of
Yes.
it.
Have you received it?
No, lordship.
Lordship, I'll furnish one.
Furnish copy. Representation has already been disposed of, and then what they're saying is,
They're entitled to.
in the light of above, it may be stated that the claim of the petitioner for payment of arrears salary with effect for so and so cannot be considered. He is entitled to receive arrear salary with effect from 2018 to 2022. You have to challenge if you are agreed.
But yet not.
Only direction is to consider a disposal of your representation only.
Can you fix on another date,
No.
lordship?
We're closing it. You take it and take a call. You can challenge this, all right? You have claimed from 2010 to 2018. Yes.
From 2018 to 2022, I have not received the area salary.
No. 2018, you are entitled. He said already it has been processed, you will get it. But this order says you are not entitled from your claim for 0104 2010 to 2018 has been
In
rejected.
this regard, I'm challenging that
You challenge it, we'll close it. This has been
Lordship, but in the regard to 2018 to 2022, I have till
This
I have
was
received.
of 2027. You give the copy. Give this copy.
Oh, yes, Lordship. If functions are available.
Heard Mr. So-and-so, learned counsel for the, once it is complied, your order is to dispose of the representation that has been done, sir.
I'm compliant, Lordship, but till that I have not received the area salary.
It doesn't say that you will be paid. Court's order, you read at page 15.
Lordship, the representation regarding the area salary.
Sir, try to understand, read the First read your the court's order and then read that. So and so, huh? Mr.
AK Ghosh on behalf of
A.K. Ghosh, learned counsel appearing on behalf of
Mr. S. Datta.
Mr. S. That learned counsel for the alleged contemner by placing the copy of the order dated 01/04/2025 passed by the Commissioner Panchayat and Rural Development Department submits that the order of this court dated 20/03/2024 has duly been complied with. Mr. Next letter. It is noticed that this court has by an order dated 20/03/2024 dispose of the writ petition directing the respondent number 6, respondent number 2 verify the entire service records of the petitioner and thereafter dispose of the representation dated 03/01/2024. Mr. By the order dated 20. Next paragraph. Having considered that the Commissioner Rural Panchayat and Rural Development Department by order dated 01/04/2024 has disposed of the representation of the petitioner dated 03/01/2024. The order of this court has duly been complied with. Thus the contempt petition is still closed.
Lordship,
And
that
this
order
order-
would be 01/04/2025.
Huh?
That order which your Lordship has said, that is 01/04/2025.
That is what I have said.
Oh,
The order of that thing. Huh?
Lordship, kindly give a direction to supply the copy.
So
I'll supply
what's
it.
there? The copy of the communication dated, the order dated 01/05/20, 01/04,
04/2025.
01/04,
Yes.
2025. Is kept on record and marked as documents X.
Lordship, my name may be recorded for respondent 2 and 1. A Soliha.
Right, Lordship.
You furnish the copy?
Yes, I'll furnish it.
You should have furnished the copy.
Lordship, I just said on one copy with me. I tried to get a printout.
No, your authority, after passing of them, it should have been communicated by furnishing the copy. Otherwise, how they will know?
Obliged, Lordship.
Yes, sir.
This case is simple, but service reports to come more than 1 year, my lord.
Huh?
This case is simple, but service report to come more than 1 year, my lord, in this case. That means service steps was taken, my lord, last.
Take a press steps.
Yes, my lord.
Take it, huh? Further, only prayer of
Mr.
that's allowed for listing of this thing. Petition is directed. As heard Mr. So and so.
Mr.
No, only prayer of Mr. So and so, non counsel for the petitioner. Further, a week's time is granted to take precise steps for service of notice upon the respondents. This after 4 weeks. Yes.
My lord, this matter, my lord, pertains to, my lord, non-payment of, my lord, it's a pension. The only thing, my lord, let the matter be fixed on a hearing day, my lord, because he is yet to receive the provisional pension.
Provisional pension has been sanctioned, your lordship, on 17th of May, your lordship. He has already received the pension.
Superprovision, that I do not have any instructions, my lord. Lordship may fix the matter on any day, in a hearing day, my lord, so that can be restored.
And your lordship, the final pension, we are not been able to proceed because the audit report has not been submitted by the petitioner.
You submitted. No, that is what, my lord. That is my case. The case was that, my lord, the documents which was not even made available to me. how can I submit, my lord? These are documents from record. That is why, my lord, the reply
Who
which
is
was
to
filed
submit it?
by my predecessor, my lord.
Huh?
By my predecessor. I was the headmaster of a school. My predecessor did not submit certain documents. I cannot, my lord, manufacture documents from my own. That is my case.
So it's not available.
No, my lord. And
It's
it is
not
on
available.
record. No,
It's not available.
no. That is my case, my lord. Now, I cannot manufacture documents and produce before them. I have stated before the authorities. It's
Okay.
on record, my lord. That is why, my lord, since it matter relates to pension.
Not
lord,
Mr. So-and-so, learned counsel for the petitioner and MS so-and-so.
D. Musari, your lordship,
for
for secondary education.
Secondary understanding for the, then
I'm for the AG Lordship, respondent number 5.
so-and-so.
Sharma on behalf of Mr. B.
So-and-so. And last one would be N, after the N, last lawyer will be there. As agreed to by learned counsel for the parties, let this matter be listed after 3 weeks.
Can it be a little early, my lord? Pension, my lord, retired in 2021.
You have you have accepted, you have received the
Even
provisional
otherwise.
after 2 weeks.
Can a date be fixed, my lord? Date.
Today, I have not given any date to anybody. No discrimination. I understand pension matters, but
Obliged, your lordship.
Wait, visitor. If the affidavit is awaited from the AITC,
yeah.
or should the affidavit is awaited?
1 week's time may be given, my lord, we'll file them.
Or Mr. So-and-so, learn counsel for the times. On the prayer of Mr. So-and-so, learn counsel for.
My lord, respondent 2, 3, and 4.
Respondent 2, 3, and 4. Further 2 weeks time is granted to file.
Worship, may I plead for 2 weeks?
2 weeks, I said 2 weeks.
Okay.
I'm deeply obliged.
In this case, my lord, there is a laws in my court order, my lord, service complete, so matter has to come for admission.
Okay, as per in view of the Laujama Court order dated 29/05/2025, service in respect of the
Already
respondent number 5 is complete. List for next list for admission after 3 weeks.
I will ask.